Good morning, everyone, and welcome to the final day of this public hearing. Ms Beattie.
Good morning, Chair. Before we turn to closing submissions, there is some further evidence that we would invite you to adduce. The first is the second witness statement of Gary Richardson, Detective Superintendent, British Transport Police, dated the 13th of March 2019. This concerns email correspondence received by the British Transport Police from North Wales Police in 2017 about Peter Morrison being taken off a train at Crewe railway station. The British Transport Police did not take any further action in relation to this. The exhibit to that statement shows that email correspondence between North Wales Police and the BTP, and the references are OHY 007098 for the statement, and for the exhibit OHY 007099. The next is a supplementary witness statement of Liz Reason, Chair of the Executive of the Green Party of England and Wales, dated the 21st of March 2019. Chair, you will recall that Ms Reason gave evidence to the inquiry on Thursday the 14th of March, and this statement deals with various matters that arose during Ms Reason's evidence. That is GNP 001006. We invite you to adduce the witness statement of Christopher Horn, dated March 2019. Mr Horn describes how during the 1972 by-election there was talk that Cyril Smith had committed sexual offences with young boys. Mr Horn, who was a supporter of the Conservative Party candidate David Trippier, says the local police took action to ensure that this information was not disseminated, including by a police visit to the Conservative Party campaign office, where the police said that any mention of Cyril Smith's predilection for young boys would be treated as a criminal offence and lead to an order to stay out of the by-election. That reference is INQ 004206. The next is a witness statement from Sir David Trippier, dated the 19th of March 2019. As already mentioned, David Trippier was a Conservative MP and previously an elected member of Rochdale Council who got to know Cyril Smith well. He was the Conservative Party candidate in the 1972 by-election. He says that during the campaign it was widely known among all the political parties that there were allegations of a sexual nature involving Cyril Smith and young boys, that allegations had been investigated by the police and a decision had been taken not to take any further action. That is INQ 004207. The witness statement of Peter Beattie, dated the 25th of March 2019. Mr Beattie worked as Sir Edward Heath's private secretary from the summer of 1982 to February 1986, based on the parliamentary estate. He describes his recollection that Mr Heath received a letter from the Paedophile Information Exchange inviting Mr Heath to attend a P.I.E meeting. Heath said, "We don't want anything to do with them." He doesn't recall any meeting with P.I.E ever appearing in Mr Heath's diary during his time as his private secretary. And that is INQ 004216. Next is the witness statement of Commander Neil Jerome, dated the 8th of February, about the searches that were undertaken on records held by the Metropolitan Police Service Special Branch, which is OHY 007085. And finally, the second witness statement of Ian Lucas MP, dated the 25th of March 2019. Mr Lucas denies having a direct conversation with Jane Lee or being involved in any cover-up by political parties in Chester. He says he has no knowledge of any pact as described in the evidence of Graham Nichols. And that is LAB 4070. Chair, that is the evidence that we invite you to adduce. And that concludes, Chair, the evidence in this investigation. I would invite you to turn to closing submissions.
Thank you, Ms Beattie. Mr Scorer.
Chair and panel, in my opening I addressed you on several issues. the Liberal Party's knowledge of allegations against Cyril Smith and its response to them, safeguarding in political parties generally, the question of whether state agencies may have covered up abuse by Smith or others, and the DPP's handling of the Smith file in 1970. I intend to address you now on those same issues in the light of the evidence we've heard, and then finish with some general observations about these hearings and the lessons from them. Starting with the Liberal Party's knowledge of allegations against Smith and its response, we heard from Baroness Brinton. The thrust of her evidence about the early 1970s was essentially twofold. Firstly, that the Liberal Party in the early 1970s was highly decentralised, and that the National Party organisation and HQ had little or no involvement in the selection of parliamentary candidates. Secondly, that the lack of salience of the allegations against Smith in the 1970 general election and the 1972 by-election indicates that these allegations were not really on anyone's radar. The aim of her evidence was clearly to minimise the involvement of the National Liberal Party in Cyril Smith's early parliamentary career, and to suggest that the allegations against him were not well known, either in the National Liberal Party or more widely. We say that Baroness Brinton's evidence on these points needs to be treated with a degree of caution, and in some respects is simply wrong. Baroness Brinton herself joined the Liberal Party in 1973, but as she confirmed, her real involvement in the party only came much later. In preparing her statement, Baroness Brinton sought assistance from two colleagues, Sir Nick Harvey and Lord Newby. Nick Harvey was born in 1961 and did not become involved in Liberal politics until the 1980s. Lord Newby came into the Liberal Democrats via the Social Democratic Party and had no involvement in the old Liberal Party. So none of them have direct knowledge or experience of events in 1970 and 1972. Baroness Brinton is no doubt right to say that the Liberal Party at this time was highly decentralised. However, in her oral evidence, Baroness Brinton went further and asserted that Jeremy Thorpe, the then party leader, had no involvement in Smith's selection because, as she put it, at that point he was almost entirely focused on the House of Commons rather than on the workings of the party. We say this is not only pure supposition on her part, but that the historical record indicates the opposite. The leading biography of Jeremy Thorpe, published in 2014, identifies that from the early 1960s onwards, before he became leader in 1967, Jeremy Thorpe was heavily involved, along with Ted Wheeler, in the Liberal Party's winnable seats strategy, the strategy whereby resources would be heavily targeted on winnable parliamentary seats. In particular, Thorpe's biographer notes that a separate bank account was opened to finance the winnable seats strategy, and that from the early 1960s onwards, this bank account was under the personal control of Jeremy Thorpe himself, as opposed to the Liberal Party organisation. This bank account, which is described by his biographer as having been maintained on a semi-secret basis to avoid other political parties learning of the strategy, remained under Thorpe's personal control when he became leader. And the biographer notes that it was still under his personal control in the late 1970s. We know this because when the police started investigating the Scott affair in the late 70s, they examined the bank account to check whether funds from it might have been misused in connection with Scott, but they discovered that they hadn't been. Given that Thorpe retained personal control of the financing of the winnable seat strategy, it seems very likely that he would have paid close attention to the selection of candidates in the seats which formed part of the strategy, of which Rochdale was one. And in any case, both Michael Seed and Michael Meadowcroft recall significant rumours that Thorpe was involved in Smith's selection in 1970. Seed says it was widely believed at the time that Thorpe had fixed it. The presence in Rochdale of Ted Wheeler, who was Thorpe's chief lieutenant on the winnable seat strategy, suggests that too. Also, the idea that Liberal Party leaders did not become closely involved in the selection of parliamentary candidates was rather undermined by Des Wilson's evidence. He told us that when the Liberals were selecting a candidate to stand at the Hove by-election in 1973, he was phoned up by David Steele and in effect offered the candidacy, even though he was not a Liberal Party member at the time. Again, this suggests a much higher degree of National Party influence over local candidate selection than Baroness Brinton acknowledged in her evidence. And finally, we also know from Cyril Smith's own autobiography that Jeremy Thorpe was instrumental in persuading him to stand at the Rochdale by-election in 1972. He says this in terms, and we'll file the relevant excerpt with the inquiry. Baroness Brinton suggested that if the allegations against Smith had been widely known about in 1970 and 1972, they would have been used against him by his political opponents. Again, we suggest that this exposes Baroness Brinton's lack of familiarity with the relevant history. In the 1970 election, Cyril Smith's main opponent was Jack McCann, the Labour Member of Parliament. Although Baroness Brinton was right to say that there has been a long tradition of hatred between the Labour and Liberal parties in Rochdale, a tradition which continues to this day, she was clearly unaware that the one exception to that was the 1970 general election, and the reason why it was an exception to the general rule was because McCann and Smith were close personal friends, something which Smith confirms in his autobiography. Indeed, as noted in the Rochdale hearing, it was suggested at the time that McCann was one of the politicians who might have intervened with the DPP on Smith's behalf. This was obviously an unusual situation in that McCann was friends with Smith even though they were political opponents, but that was the situation and the record shows it. Incidentally, this is also a point which Baroness Brinton would have registered if she had read the Rochdale Alternative Paper article, because it's referred to in there, so it may be that, like Lord Steele, she didn't read that article in advance of the hearing. As regards the 1972 by-election, the inquiry has adduced the statements which I obtained from Sir David Trippier and Christopher Horne. Sir David, who was the Conservative candidate at that by-election, confirms that it was widely known amongst all the political parties at the by-election that there were allegations against Cyril Smith involving indecency with boys. He explains in his statement that the Conservative and Labour parties felt unable to pursue the matter because their understanding was that the police had investigated and decided to take no further action, and making any allegation would therefore incur the risk of legal action for slander. Sir David has confirmed in his statement that it was only when he spoke to me that he became aware that, in fact, Lancashire Police had recommended the prosecution of Cyril Smith in 1970. His understanding in 1972, when he was the Conservative candidate, was that the allegations had been investigated by the police and that they had decided on no further action. He explains that on that basis the subject was considered taboo, but it was definitely widely known about. And in fact, Baroness Brinton did acknowledge in her evidence that in 1972 the Rochdale Alternative Paper approached the Liberal agent in the by-election with the story. So all of this supports Dominic Carman's suggestion that by the time we get to 1979, these allegations against Smith had been known about at National Liberal Party level for many years. And indeed, when you consider the Liberal Party press statement on the 22nd of April 1979, this also confirms institutional knowledge on the part of the Liberal Party at Westminster of the allegations against Smith before the Rochdale Alternative Paper article was published. The Liberal Party press statement, suggesting that Smith had, quote, just spanked a few bare bottoms, could only have been issued if there had been some prior knowledge on the part of the Liberal Party that such allegations had been made against Smith. As I said in my opening, this is at odds with David Steele's claim that he only found out about the allegations for the first time in 1979. So we say that the reality is that the National Liberal Party was fixed with full knowledge of these allegations from 1970 onwards, but simply took no action to investigate them. We then turn to the evidence of Lord Steele. He told the inquiry that in 1979 he put the allegations in the Private Eye story to Smith, and that Smith confirmed that the story was correct. He confirmed to the inquiry, under oath, that his understanding was that the allegations against Smith were true. The day after giving his evidence to this inquiry, having unleashed something of a furore, and also facing the prospect of suspension from the party, Lord Steele sought to quote-unquote clarify his evidence, to walk it back, as the saying goes. He tried to suggest that when he told the inquiry that Smith had told him that the Private Eye story was correct, what he really meant was that it was correct that the allegations had been made. In other words, Lord Steele attempted to add a qualifier to the phrase, Smith told me that the account was correct. However, the simple fact is that his evidence to the inquiry contained no such qualification, and he also told the inquiry that he understood the allegations against Smith to be true. In any case, the explanation for his inaction that Lord Steele gave, both in his written witness statement to the inquiry and in his oral evidence, was not that he didn't believe the report or that he wasn't sure whether it was true. His explanation for his inaction was that Cyril Smith was a member of a different party at the time, and indeed hadn't been an MP when these events occurred. On that basis, he claimed that he didn't have any locus to act. So that explanation from Lord Steele of his inaction only makes sense if he thought the allegations were true. If he didn't think they were true or just didn't know, he would have given a different explanation for his inaction. We note that Lord Steele has said various things on this issue over the years, some of them contradictory. At one point in 2014, he seems to have been quoted by the BBC as saying that he knew nothing at all about the allegations in 1979. However, his evidence to this inquiry is the only time he has given evidence on this subject under oath. It is also the only time that he has been exposed to the systematic and searching questioning on this subject that he underwent from Mr. Altman. So we say that it can be the only account that you can rely on. We also say that Lord Steele's evidence entirely validated Des Wilson's analysis. Steele just didn't want to confront Smith and buried his head in the sand, as he continues to do. A complete abdication of responsible leadership. Chair, given Lord Steele's evidence, we urge you to do several things in your report. We urge you to condemn Lord Steele's inaction itself, which we say was completely unacceptable and unconscionable, and indeed very likely permitted Smith to commit further abuse, given that Smith's access to Knollview School in the 1980s arose by dint of his status as a Member of Parliament. Secondly, we urge you to condemn in clear terms Lord Steele's attitude when he came to this inquiry. Far from recognising the consequences of his inaction, he was completely unrepentant. He did not apologise. There was no evidence of him learning the lessons from his failure. On the contrary, he made it clear that he would behave in exactly the same way now in the face of the same information. The claim that he had no locus to act on something which predated Smith's time as an MP is clearly ludicrous. Would he seriously say that about any other crime that Smith might have committed? Thirdly, we urge you to condemn his attempt to renege on what he said to this inquiry 2 weeks ago by suggesting that the storm had been whipped up by what he called sensationalist press headlines. We checked the press headlines the following day, and they were headlines which simply quoted his own words to the inquiry. We say, Chair, that all of these things need to be condemned in the strongest possible terms, and anything less than that would make a mockery of this inquiry, and indeed would give the green light to other politicians and senior leaders in society to ignore abuse should they be presented with clear evidence of it in the future. I then turned to the Liberal Party inquiry in 2012. Baroness Brinton suggested that her party had attempted to examine these events comprehensively. The conclusion reached by the 2012 Liberal Democrat internal inquiry was seemingly, and I quote, that no evidence was found to suggest that the party was aware of the allegations against Cyril Smith or acted in any way inappropriately. This is self-evidently absurd. Given what we know, only a total sham of an inquiry could have reached such a conclusion. This inquiry was anything but comprehensive. At the end of his evidence, Des Wilson was asked whether he had been contacted about the party inquiry in 2012. He confirmed that he hadn't been. This is extraordinary. You would think that the very first category of witnesses who would be contacted for a proper party inquiry would be former presidents of the party, particularly those who had been active in the party for many decades. They would be the obvious people to have institutional knowledge of how Cyril Smith was dealt with over the years. It wouldn't have been difficult to contact Wilson, but the Liberal Democrats failed to do so. Nor did they make any attempt to examine Lord Steele's own explanation for his inaction. There was no systematic questioning of the kind we heard here. Therefore, we say that this so-called inquiry in 2012 was effectively no inquiry at all. The simple fact is that the Liberal Party and their successor party, the Liberal Democrats, failed the victims of Cyril Smith over many decades, and they deserve to be called out for it. I've been asked by my clients to put on record their anger and disgust not only at Lord Steele's attitude, but at the failure of the Liberal Democrats to truly acknowledge the party's failings in this regard, other than Des Wilson, of course, the one honourable exception. For my clients, the clock can't be rolled back. The abuse they experience cannot be erased from their lives. But they hoped at least for contrition, for an acknowledgement of failure, and a sense of lessons truly being learned by the Liberal Democrats. Sadly, our clients see none of those things. This leads me on to the subject of safeguarding arrangements in political parties today. Everything we've heard in this inquiry, whether in relation to the Liberal Democrats or any other party, suggests that safeguarding at Westminster has a long way to go across all parties. I made the point in our opening that it's one thing to have a safeguarding policy. It's quite another to embed that policy in party culture so that MPs, party officials and party activists understand it and clearly abide by it. Perhaps the clearest example of that in this hearing was the evidence of Nick Brown, the current Labour Chief Whip and one of Labour's most experienced parliamentarians. He commented that if confronted with an allegation of child abuse, he would make his own assessment of the credibility of the allegation before deciding whether to pass it on for investigation. In so doing, he rather confirmed his own ignorance of the fundamental principle of safeguarding, that an allegation should be examined by an independent person with safeguarding knowledge and expertise. A decision on credibility shouldn't be made by a chief whip who has no safeguarding expertise and who may well have a pre-existing relationship with the person being complained about. So we suggest here you have an illustration of the depth of the problem at Westminster. The Labour Party policy looks great on paper, ticks all the boxes, but the chief whip, who is actually more likely than anyone to be in receipt of an allegation, doesn't entirely understand the policy or the philosophy behind it. And this is actually in a political party which in its public policy platform is officially committed to mandatory reporting. So clearly in your report you'll need to do much more than simply recommend that every party has a state-of-the-art safeguarding policy. You need to look at how compliance with that can be made mandatory, and it seems to us that that will inevitably necessitate an element of sanction for failure to comply. I then move on to the subject of state cover-up. You heard various evidence suggesting that state agencies had in some way covered up the abuse of children. I focus on those allegations relating to Cyril Smith. Robert Glenn gave evidence that in early 1978 he was an inspector at the club's office when one of his teams presented him with evidence which merited the obtaining of an arrest warrant for Smith. Glenn stated that it was quite clear that there was good evidence to suggest that Cyril Smith was involved in obscenities with young boys. Glenn gave compelling evidence that his superior, Chief Superintendent Diver, closed down the operation on the basis that it was, quote, far too political in nature and would cause political upheaval if we went through with the arrest of Smith. We say that Glenn was a straightforward and plainly honest witness who gave clear testimony to the inquiry. The motive for Diver shutting down the operation may have been personal rather than orders from higher up. On what we know, either explanation seems possible. Glenn's evidence of an inquiry being shut down was corroborated by Holmes, who clearly recalled it too. Holmes, we say, was an exceptionally compelling and impressive witness with an impressive recall of events and the surrounding context. He said the name, and I quote, "The name Cyril Smith was not news, it was expected. We anticipated that he may be seen. I didn't speak to Bob Glenn about any of this at the time, but I had close ongoing squad relationships with Dick Griffin and Pete Lamb, who were the most frustrated officers because they were the ones who had done all the work and had been stopped." When asked if he meant that he actually knew that about what Glenn was telling the inquiry, that he knew that either Griffin or Lamb had been the sergeants working on a covert investigation into Cyril Smith, which had been shut down by Diver, and that he knew that at the time, Holmes was unequivocal in answering yes. So we say that both Holmes and Glenn were persuasive witnesses whose evidence on this matter the inquiry should accept. I'll come to the IOPC in a moment, but it follows that the conclusion of Operation Beach, that Glenn's allegations are not corroborated, is clearly wrong. And of course, earlier this week, Brian Collins told us that allegations about Smith and Rent Boys were widespread in the force at this time. Holmes also gave detailed and compelling evidence on a second operation in the summer of 1978, confirming Glenn's evidence that officers in the club's office took part in covert surveillance and intelligence gathering, in contrast to what P.I.E told the IOPC in Operation Beach. He spoke of a surveillance operation he undertook with Sinclair in the summer of 1978, focusing around Rodham Twiss. He explained that this operation was based on reliable informant evidence, and he recounted that the operation was terminated after Sinclair, rather unwisely in his view, spoke to a superior officer in the club's office about extending the operation. Sinclair and Holmes were quickly reallocated to another inquiry. Holmes concluded that their covert surveillance operation into Twiss could have been stopped for any one of three reasons. One, that very senior officers were actually criminally involved themselves with the homosexual vice world. Secondly, corruption in the sense of receiving money to terminate inquiries, although Holmes himself didn't feel that this was likely. And thirdly, the possibility that an investigation exposing a person of prominence would have been unwelcome to an ambitious senior officer with aspirations to rise further. We say again that Holmes's analysis was compelling and clearly based on a deep knowledge and detailed recall of police operations at the time and the surrounding context going back to the Playland investigations of the early 1970s. His highly credible evidence was referenced in the Operation Conifer briefing paper but has not yet been properly investigated by the IOPC in a separate investigation, and it's clear to us that the IOPC should now fully investigate his allegations. Finally, Holmes made interesting points about the organised abuse of so-called rent boys in the 1970s. He identified that much of the offending was perpetrated by what he called the upper echelons of society, a term he explained embraced the wealthy and the aristocracy much more than politicians at Westminster, who he indicated were not the main element. Holmes's point here is supported by the ban on Rodham Twiss entering the Palace of Westminster. Secondly, Holmes explained that after the Playland trials in the first half of the 1970s, there was a change in the modus operandi of sex offenders from the upper echelons of society. Rather than risk being caught curb crawling for rent boys directly, offenders shifted to using middlemen as procurers to reduce the risk of detection. At first blush, that might seem inconsistent with a person of prominence such as Smith being under surveillance for curb crawling. Surely, if Holmes is right, he would have used a middleman to do his procuring. However, we say that the Smith case in fact illustrates Holmes's point rather well. Smith was precisely the sort of person who, by reason of his northern working class background, was unlikely to have had access to the upper echelons of society and the procurers they used, and so would have had to continue to do the procuring himself. Additionally, we heard evidence from another former Metropolitan Police officer, Howard Groves. This related to a slightly later point in time, the early 1980s. Again, Groves was clearly a diligent and committed officer and an entirely honest witness. There is no reason to doubt his recollection that at the commencement of his involvement in Operation Circus, he was given to understand at a briefing or a meeting by a superior that any operation which ensnared a high-profile public figure would be closed down. In a sense, the specifics of precisely how and when this was said, whether it was in a formal or informal setting, make little difference because it was never acted on. But the important point is that it was clearly implied, and so is evidence of the culture of deference in operation at that time. I then turn to the issue of Smith and the DPP, and whether Smith was protected from prosecution in 1970 by the intervention of a politician or politicians with the DPP, as was rumoured at the time, with Roy Jenkins's name being mentioned. I set out in my opening the timing and sequence of events in 1970, with Smith being selected as Liberal candidate on 2nd of March, before the DPP's decision had been made, but with Smith having previously made clear that he would not seek the candidacy if prosecuted, and that this strongly suggests that the DPP's decision was preordained. In this hearing, we heard some further evidence, both specific and general, relevant to this issue. Lord Jopling told us about his conversation many years ago with Sir John Cobb QC about Sir John being instructed by the DPP to advise on offences in relation possible offences committed by Smith. Lord Jopling was unsure whether this happened around 1970 or a bit later. We say that even if Jopling's recollection is correct, it is highly unlikely that this could have related to the Lancashire Police investigation. As Council identified earlier this week, the papers were sent to the DPP on the 13th of March 1970, a Friday, and acknowledged, presumably received and acknowledged by the DPP on Monday the 16th of March. The letter back from the DPP containing the recommendation against prosecution was sent on the Thursday 19th of March. The letter from Mr Hutchison, the lawyer at the DPP's office, makes no reference to any opinion of counsel. It must be highly unlikely that any opinion of leading counsel, especially a leading counsel this eminent, would not be referred to in the letter if it had been obtained on this occasion. Also, the window in which counsel's opinion would have been obtained was clearly too short for this to happen. The file being received by the DPP on the Monday, this was in the pre-email age, the file numbering some 80 pages, and as stated, the recommendation against prosecution being sent back on the Thursday. It is virtually inconceivable that an opinion could have been obtained from leading counsel in that very short window. So we submit that whatever was being referred to in the conversation recalled by Jopling cannot have been this instance. This raises the obvious concern that there may have been a separate police investigation on which the DPP obtained counsel's opinion, but we say it clearly wasn't this one. We heard other evidence in this hearing which reinforces the likelihood that political pressure on the DPP would have been effective. We heard from Lord Taverne. Although his evidence concerned the stance of the police and the then Home Secretary Roy Jenkins towards prosecution of consensual adult homosexual activity, Lord Taverne's evidence was highly illuminating about the culture of the time. When Jenkins met with the Met Commissioner to discuss police policy in regard to cottaging, and Jenkins asked the police to stop pursuing offenders, the Commissioner responded by pointing out the constitutional impropriety of the Home Secretary instructing him on how to deploy his officers. However, the notable point is that despite his objections, the Commissioner still acceded to the Home Secretary's demand in any event. The Commissioner did what his political master wanted him to do, even if he felt the demand was constitutionally wrong. That's the first point. Second, we learnt that even before the meeting, the Commissioner had already unilaterally decided not to uphold the law on cottaging around Westminster. The Commissioner seemingly did this of his own volition. He didn't even need to be told to do it. And as Lord Taverne explained, his reason for doing it was to avoid embarrassment to politicians. So this wasn't a case of the Commissioner deciding not to prosecute because society regarded the law as outmoded or because the law was about to change anyway. That's not the reason he gave. The Commissioner said that the reason for not upholding the law around Westminster was that it would be, quote unquote, embarrassing to MPs and peers. We say that's a very illuminating statement about the culture of deference at the time. In fact, Chair, there is also evidence from other sources of Jenkins behaving in that sort of way. The book A Very English Scandal describes an incident in 1975 or 76 when the Jeremy Thorpe scandal was becoming public and Norman Scott was causing the Liberal Party increasing problems. The chief whip of the Liberal Party at that point was Cyril Smith, and Roy Jenkins was in his second stint as Home Secretary. The book describes how Cyril Smith went to see Roy Jenkins to ask for help, and Jenkins offered to assist by drawing the attention of the police to Scott's mental health problems. So here we have Jenkins using his power to help a fellow politician in difficulty, and interestingly, we also have Smith clearly seeing Jenkins as somebody who would be willing to assist. Lord Taverne also confirmed that regular discussions would take place between the Home Office and the DPP. Whilst the conversation described by Taverne was between the Home Secretary and the Met Commissioner, there is no reason to think that the culture of deference and political influence on display would have been any different in any other part of the system. Indeed, there is other evidence from this period demonstrating the DPP's deference and susceptibility to political pressure. In 1975, a young barrister called Geoffrey Robertson wrote a book, Reluctant Judas. This detailed how the then DPP had approved an arrangement whereby a witness in a terrorist trial committed perjury in order to protect an IRA informant. The arrangement was sanctioned by the DPP whilst being unknown to the trial judge and to counsel. In other words, quite simply, the DPP allowed a trial to be rigged in order to serve wider political purposes. So clear evidence from that period of the DPP giving way to political pressure. And we also got a flavour from Mr Norton of the culture of the DPP in those days, with the Hayman case being carved up in a private chat between Sir David Napley and the director himself. As one article put it, a man being exempted from due process of law because he was well known. Mr Norton's only beef about this seems to be that as the file handler, he would have preferred to be present to take a note. He told us that he would never have dreamed of asking for an explanation. As he put it, it would have been impertinent for me to question the decision. So on the question of Smith and the DPP, although it is impossible, clearly, to be certain whether a senior politician interceded on Smith's behalf, two things are clear. The sequence of events is strong circumstantial evidence of an intervention. Secondly, the culture of the time, as laid bare by Taverne and Norton, was such that any senior politician who sought to intervene with the DPP was unlikely to be disregarded. He would be pushing an open door, even more so when we see the dismissive attitudes to child sex offending within the DPP, as illustrated by the Montague and indeed Hayman cases. So whilst we have no direct evidence that somebody intervened with the DPP, I submit that we have strong circumstantial evidence and evidence of the culture of the time, suggesting that it was likely to be successful, and I invite you to reflect that in your report. Chair, against the background of that widespread culture, evidence of a widespread culture of deference, I want to finish with a few observations about the approach of the IOPC. As noted in their overview report, the IOPC has a statutory duty to secure and maintain public confidence in the police complaints system in England and Wales. Their reports need to be judged through this prism. On the culture of deference, you've heard in this inquiry countless examples from the police and DPP and others of a culture of deference to prominent persons and the higher echelons. I've touched on some of them here, and I scarcely need to list them all. However, in the face of that overwhelming evidence, in their oral evidence to the inquiry earlier this week, Mr Mahaffey and Ms Roper denied that there had been a significant culture of deference in the force, both towards superiors and those of public prominence. Ms Roper stated that she did not recognise that culture of deference. I want to be clear that we certainly do not question in any way the professionalism of either Ms Roper or Mr Mahaffey, but we do say that their failure to acknowledge the overwhelming evidence of that culture is a cause for concern. Ms Roper dismissed the evidence of hoodless given in Operation Jordana as being not symptomatic of a culture of deference within the police force because it happened in a pub. But that surely ignores precisely what we learnt from the Macpherson report, that canteen culture can be as important in shaping the culture of an organisation as official top-down orders. The pub conversation reflects the culture of the force, and it clearly reflected the culture of deference within this force to people of prominence. In her evidence, Ms Roper also seemed to try to say simultaneously that nothing was wrong in the past, that all was well, but yet there had been huge improvements, lots had changed, and things were different now. We submit that it has to be one thing or the other. Either there was a problem in the past which has now been tackled, or there wasn't a problem and therefore no improvements were needed. And we say this matters because policing and the investigation of police misconduct cannot command public confidence without honest and critical reflection about where things have gone wrong in the past. Indeed, not only did both officers fail to acknowledge the culture of deference, which plainly existed during the period under examination, but they also gave evidence which suggested that they may themselves, however unwittingly, be continuing to operate within a continuing culture of deference today. Ms Roper spoke of a need to take a more, quote, holistic approach to the arrest of persons of prominence and to be mindful of the impact that such an investigation could have. It wasn't entirely clear what this meant or what tests would be applied, but we say that equality before the law requires that if the threshold for arrest is met, then the suspect should be arrested, however prominent he or she is. So their evidence on that point did leave a nagging concern that to this day persons of public prominence may be treated differently to others, and that cannot be right. We say that a further issue with the IOPC is a failure to systematically draw together the relevant investigations to identify common themes and concerns. The risk is that individual IOPC investigations are conducted in a slightly siloed fashion with insufficient analysis of how some of the investigations may relate to each other. An example of this is that in Operation Osier there was a failure to recognise that Hoodless in Operation Jordana was at least in part corroborating what Groves was saying about the operation being shut down if persons of prominence were found. It seems that the two officers were talking of different conversations that had been had about this, Groves in a team meeting and Hoodless in a pub with colleagues, but it seems clear that this was evidence of a culture of the time which should have been joined up and properly commented on within the report rather than Groves' allegations being dismissed as uncorroborated. Mr Mahaffey acknowledged in oral evidence that the conclusion reached within the IOPC report that Groves' allegations cannot be given any provenance must now be revised given the evidence of Hoodless, which wasn't adequately analysed and taken into account when conclusions were drawn. Similarly, there is a failure on the part of the IOPC to identify the corroboration that Paul Holmes has now provided to this inquiry in respect of Glenn's allegations. If the IOPC had opened up an investigation into his claims and interviewed him thoroughly about his time at the club's office, no doubt he would have told them what he said in oral evidence here. We identified earlier some further work which we think the IOPC needs to do on this and other matters. In terms of recommendations for the future in relation to the IOPC, we suggest 4. Firstly, part of the reason why the quality of Holmes's evidence may have been overlooked may have been because he was interviewed over the phone rather than face-to-face. In this context, this was clearly a false economy, and this mistake should be avoided in the future. Secondly, the IOPC should attempt to make a more rounded and reflective assessment of the credibility of witnesses that they have interviewed. Thirdly, the IOPC has the power to compel serving police officers to attend witness interviews in specified circumstances. Given the apparent reluctance of some retired officers to assist with these investigations, we suggest that this power be extended to former officers in certain investigations where serious allegations are being made. And fourthly, as alluded to by Mr Frank, we clearly need new regulations regarding the retention and destruction of police files and documents. Chair, I'll now bring this to a close. We have a number of observations regarding both the Don Hale evidence and the events of 1976 relating to Andre Thorne. Because of time constraints, we'll set out the detail of that in our written submissions. However, we suggest that a common thread linking those two subjects can be expressed in the words of Giles Brandreth: mystery makes for mischief. Conspiracy theories fester in the dark. In our view, the conspiracy theory advanced by Don Hale lacks credence when his claims are examined against the historical record. But for that to happen, the historical record has to be open and transparent for all to see. And we will make a number of suggestions about how you might approach that in your report. Chair, in our opening submissions, I said that during the course of this 3-week investigation, we would go where the evidence takes us. In 2014, when this inquiry was established, rumours of VIP paedophile rings were at their height. Some of the headlines from that period were lurid, sensationalist, and highly questionable. Through this inquiry, some of those conspiracy theories have been exposed as the fictions that they always were. But that does not mean there is nothing to see here. Indeed, what has replaced the more fantastical conspiracy theories during the course of this inquiry is perhaps less salacious for the media, but we say far more concerning. From Cyril Smith to Peter Hayman to Viscount Montague, these hearings have uncovered real and compelling evidence of men evading justice because of their power and social status. There has been evidence of cover-up, of more favourable treatment, and of deals being done. The evidence has demonstrated a real culture of deference to people of public prominence and a failure by political parties to grasp even the basic elements of safeguarding. As we said at the beginning, political parties and state bodies have failed to treat the welfare and safeguarding of children as even a factor to be considered. The welfare of children has been a distant concern. We hope, Chair, that the cultural change we called for at the start of this inquiry has at least begun through the process of these 3 weeks of hearings and will now be driven through from top to bottom. Thank you.
Thank you, Mr. Scroll. Mr. Price.
Madam Chair, members of the panel, as you know, I represent Ms. Esther Baker, a core participant in this strand who has attended much of this hearing. As I noted at the outset, the value of this strand of the inquiry to Ms. Baker and other survivors is potentially very significant. In her opening remarks through me, Ms. Baker made the point that whilst anyone accused of child sexual abuse has a lot to lose, those in power have the most of all. And she pointed out the other unique or unusual features belonging to powerful men at the heart of government: wealth, ready access to legal resources, pre-existing relationships with the national media and those in power, and of course, power itself. She suggested that the combination of these factors creates an atmosphere of extraordinary hostility for complainants. What is apparent following the evidence heard at this hearing is that this hostility extends also to whistleblowers. At the outset, Ms. Baker indicated that she would be seeking to focus in particular on the following 3 issues: political parties' HR and whip functions, treatment of survivors, and the issue that the wider criminal justice system has a practice, mostly implicit, of treating powerful people differently when it comes to accusations of child sexual abuse. In relation to the first point, Ms. Baker has serious reservations about the evidence given to the inquiry by the Liberal Democrats and whether it accurately accords with her own personal experience. That is an issue she has now taken up in writing, and we understand that the Liberal Democrats will be seeking to correct a position with the inquiry in due course. The latter of Ms. Baker's 3 points, that the wider criminal justice system treats powerful people differently when it comes to accusations of child sexual abuse, has cropped up over and over again in the evidence heard throughout the last few weeks. The panel will recall in particular the following. Howard Groves spoke of the culture of deference in the police force that he believed worked directly against good safeguarding practice. Whether explicit or implicit, he was clear. If he and his colleagues encountered people of public prominence, any inquiry upon which they were embarked was to cease. That was his understanding. That was his practice. Robert Glenn's evidence was that he knew that it would cause what he described as political upheaval if he had gone ahead and arrested Cyril Smith. According to him, there was ample evidence to support a warrant, but it would never have got past his superior officer. This is supported by the evidence of Glenn's commander as given to the Beach investigation. Because the investigation into Smith related to an MP, even he, the commander, believed he didn't have the authority to make relevant decisions. As it was put by Mr. Fulston in his evidence to the inquiry, the system was protecting the man and not investigating him. For anyone who has ever found themselves confronted by the establishment, we all know that the man in Mr. Fulston's sentence isn't just a particular person of public prominence, but the embodiment of that establishment. The system was protecting the man and not investigating him. As explained by Mr. Holmes, the approach taken back then was that it was unlikely that any of the victims would talk to the police, because the approach of the police was always sceptical. Sex workers, as he described them, and this included the young boys and girls who hung around in Piccadilly, were treated as second-class citizens whose word was worth little or nothing. Victims want to be believed, he said, but cases were often closed if there was not enough evidence other than their word. Alcohol abuse and proven lies about extraneous matters all conspired to destroy the credibility of such witnesses and ensure that they would never be believed. As he asked rhetorically, how could I tell them it would all be okay if they gave us a statement? Mr. Holmes provided a further insight into the subtle insidiousness of the attitude amongst police to investigating people of public prominence. If you're ambitious, he said, you don't need this. We heard that it would be career-ending. Brian Collins was quite clear as to how Sir Peter Hayman had avoided prosecution, where his correspondent Wardell had been tried and convicted. Wardell was a bus inspector. He didn't have Sir David Napley representing him. Yet Wardell was prosecuted for and convicted of exactly the same, convicted for exactly the same material that Hayman had only been cautioned for. It would be easy to assume that these kinds of attitudes and working environments can be explained away by the generation gap. The stories we heard about the scene in Soho and the manner in which it was policed in the 70s and 80s call to mind what we might have assumed were fictional and somewhat over-the-top accounts of the period in books, film and television. The almost comical vernacular imparts to those episodes a kind of detachment which masks the ghastly reality. We heard stories of 10 and 11-year-old street rats, boys who were, we were told, prostituting themselves in the meat rack around Leicester Square. We heard how the Vice Squad were permitted to run their own investigations, even using their personal vehicles, in that area, and how corruption was at one time pervasive. But these are not purely historical events. They are within the living memory of most of those now making the same decisions today. In Miss Baker's experience, the attitudes that prevailed then persist today. And the damage that was done certainly lives on in those many victims who have survived that era into adulthood. What we have heard confirms in our submission that there was sufficient evidence to bring to justice, at the very least, Cyril Smith, Peter Hayman, Peter Morrison and Victor Montague. As any good policeman will tell you, the value of such high-profile convictions would have had a knock-on effect beyond the narrow circumstances of their own offending or potential future offending, and is likely to have deterred further offending by others in a similar position to them, sending a strong signal that such offending would be punished quickly and decisively. Those opportunities were lost. As we said in opening, the report now has the potential to demonstrate to Ms. Baker and those in her position that the system and processes in which they have been caught up really does care about them more than it cares about protecting the man, the powerful institutions, and the men who have traditionally run them. Thank you.
Thank you, Mr. Price. Mr. Wagner.
Thank you. Chair and panel, I appear for Harvey Proctor, who sits in this hearing room today. I'm led by Geoffrey Robertson QC and instructed by Mark Stevens CBE of Howard Kennedy Solicitors. I convey Mr. Robertson's regret that he cannot be here today as a result of a long-standing commitment. However, we have prepared these final remarks together and he fully endorses them. We opened by saying that sometimes there is smoke without fire. In the case of the hideous allegations against Harvey Proctor, there never was a fire. There was instead a belching smoke machine. We have now had 3 weeks of hearings with evidence from politicians, police, the secret intelligence services, public servants and others. Where has this left us? Behind the smoke, there is no credible evidence to support any allegation against Harvey Proctor. The evidence to this inquiry has cleared him completely. There is no evidence of any Westminster paedophile network. The evidence to the inquiry confirmed it never existed. The police, Independent Office for Police Conduct, and MI5 have all considered these issues in at least 72 independent investigations. Their evidence to this inquiry was, without any reservation, that there was no corroboration for the allegations against Mr. Proctor or of any Westminster paedophile network. We have 3 closing submissions to make in summary. First, as chair and panel of this inquiry, your report should clearly exonerate Mr. Proctor. Based on the overwhelming evidence which the inquiry has now heard, no other conclusion is open to you, and you have a moral duty to say so. Secondly, the inquiry must, for both principled and practical reasons, carry out a further investigation into the treatment of Harvey Proctor and other people of public prominence by the Metropolitan Police in Operation Midland, a Westminster investigation Part 2. Thirdly, the inquiry should make recommendations to ensure that such treatment is never repeated, and that an effective investigation must mean an investigation that is fair. I will now expand on those 3 points. Our first submission is that in its report, the inquiry should clear Harvey Proctor of the heinous allegations that have surfaced in public from time to time, that he was part of an alleged Westminster paedophile network in the course of which he tortured or even killed small boys. He is grateful to the inquiry for commissioning investigations and calling evidence which exonerates him, and indeed proves there was no such thing as a Westminster paedophile network. Regrettably, in the moral panic which ensued after Jimmy Savile's crimes came to light, malicious conspiracy theories against Harvey Proctor and others were given far more credence than they deserved. He suffered and still suffers grave reputational and grievous material damage, as well as personal pain and suffering as a result. We do not for a moment seek to minimize the importance of unearthing historic child sexual abuse and bringing perpetrators to justice. Indeed, we argue that this purpose is best served by a system that rejects, at an early stage, false allegations and focuses on those that can be corroborated. But it's an uncomfortable truth for this inquiry that the public and political outcry which led to it being established involves senior politicians, the Metropolitan Police, and certain journalists, including the now defunct Exaro news agency, giving credence to malicious and false allegations. They all behaved irresponsibly, and in the case of senior police officers, negligently. The allegations were so incredible that any reasonable person would have at least treated them with extreme caution. Instead, a small group of self-promoting politicians, including Zach Goldsmith, John Mann, Simon Danchuk and Tom Watson, amplified the allegations and used their considerable political clout to give them status and believability. And when, in 2012, Mr. Watson raised the issue in Prime Minister's questions, he became a vehicle for conspiracy theorists and a patsy for fake news. The evidence which the inquiry has heard over 3 weeks points in one direction. The allegations against Harvey Proctor relating to the Elm Guesthouse, child sexual abuse and murder have no foundation. They are wholly false. As Sir Richard Omrique declared in his report, the Elm Guesthouse is equally fantastical. There was no VIP paedophile network at Westminster, and a fortiori, no cover-up of any such network.
How do people know? We were there. Why don't you listen to us? We haven't even had a voice. We haven't. We've been shut down straight away. We haven't been heard. He's allowed to stand there. No. It's just...
Chair. On day 2 of your hearings, Chris Mahaffey of the Independent Office for Police Conduct confirmed that in 36 of 37 of their investigations, no evidence has been obtained to support allegations of police misconduct. The only potential misconduct identified has nothing to do with the issues involving Harvey Proctor. No police misconduct has been identified in relation to any cases involving the Elm Guesthouse. No matters have been referred to disciplinary or criminal proceedings. On day 4, Commander Neil Jerome of the MPS gave an overview of 11 separate investigations which relate to Elm Guesthouse. He confirmed, no single Elm Guesthouse list was ever found during police investigations while the guesthouse still existed in the 1980s. The so-called guest list only emerged in very recent years from Chris Fay and Mary Moss. Commander Jerome said it's certainly very clear that evidentially the list has no value, and how it's been created is certainly dubious. In his second statement to this inquiry, Commander Jerome said, quote, I'm content that there is no evidence of a Westminster paedophile network, or of any attempts to cover up or suppress the existence of such a network. I will deal briefly with Chris Fay. He claimed that a number of prominent people attended the Elm Guesthouse, including Harvey Procter, but he never produced any evidence to back those claims up. The inquiry should accept the conclusions of investigating officers such as DCI Paul Settle that Chris Fay, who dragged Harvey Procter's name through the mud, is wholly unreliable. In 2012, Fay had just been released from prison. He had been convicted in the previous year of defrauding pensioners. The BBC website said at the time that he was part of an Olympic property fraud gang. The sentencing judge called it an outrageous and elaborate fraud, which hit those who could ill afford to lose money. The scam was widely reported, and evidence of Fay's involvement easily available by a simple Google search. It's extraordinary that Tom Watson and others gave Fay any credence at all, let alone believed him as they appear to have done. As a senior politician, he had research assistants, and it's astonishing that they did not warn him of Fay's criminal record. DCI Settle said in his statement to this inquiry that he found Fay's behaviour to be duplicitous. Commander Jerome said there was no evidence he was able to provide to back his claims up. There was, he said, no corroboration, and there were significant inconsistencies in accounts given to the police. In conclusion, Commander Jerome said, and I quote, the conclusions are that the credibility of Chris Fay is called into question, that there is evidence that does not prove his claims. There's absolutely no substance to those at all, and the overall conclusion is that there is no evidence to substantiate any of Mr. Fay's claims. It doesn't get any clearer than that. On day 6, the MI5 witness confirmed that, quote, no material was found to indicate either the existence of a Westminster paedophile network or any attempts to cover up or suppress information about the existence of such a network. And so, the evidence exonerating Harvey Procter is impressive and compelling, as is the evidence that Chris Fay is a conspiracy theorist, a dishonest criminal, a fantasist, and a liar. The inquiry should make both of these points clear in its report. You should deal the same way with the allegations of Anthony Gilberthorpe against Harvey Procter. Your investigations show that Gilberthorpe is a deeply malicious man, harbouring hatred towards the party that rejected him. He was a drunkard and a bankrupt, desperately in need of money. He wanted £40,000 to put his name to these libels and was offered £12,000. We do not know what he finally received from the Sunday Mirror. Despite extensive investigation, there is no confirmation of his fantasy allegations. Harvey Procter's name was added by these defamers because, as we explained in the opening, he was fined in 1987 for indecency in circumstances which would not have been a crime a few years later. His case was widely and sensationally publicised, which is why these liars think they can give credibility to those lists by adding his name. One of the key purposes of a public inquiry is to put paid to public concerns and scurrilous rumours, and you in your report will be judged about how you do that by, amongst others, clearing Harvey Procter. If you did so, you would merely, but importantly, be confirming the evidence you have heard from senior officers, and indeed the evidence you have, although it's not been published, of Sir Richard Henrique, who said in his report, as part of this process, I've interviewed or corresponded with several innocent persons accused of grave criminal offences. Harvey Procter must stand first in line, having been accused of the murder of 3 children, in addition to a catalogue of the gravest sexual offences. He is, in my judgment, an innocent man. Of course, you have been advised by your counsel you should not make findings in respect of this issue. If by this it's meant to deter you from commenting that Harvey Procter is innocent, then as we said in opening, it is the wrong advice, and you are not obliged to accept it. You must act according to your own sense of morality and good conscience. You have heard the evidence gathered at great public expense, and if you accept that the public will expect you to say, if you accept it, the public will expect you to say that there is no Westminster paedophile ring, and you should endorse the conclusions of Mr. Justice Enrique, Harvey Proctor, the only living victim of this hideous smear campaign, is an innocent man. I'll move on to my second submission. There may be no fire behind the smoke, but in Harvey Proctor's case there is a burning injustice. The inquiry must not conclude its work without addressing it. The presumption of innocence is at the heart of our criminal justice system. It is described as the golden thread which runs through our common law. It's a central feature of Article 6 of the European Convention on Human Rights, the right to a fair trial. In Harvey Proctor's case, that principle was turned on its head. Harvey Proctor has faced the most hideous allegations imaginable of child abuse and child murder. He was treated as guilty until proven innocent. The Metropolitan Police gave the press enough information to identify him, and then said publicly, without corroboration or proper investigation, that the incredible and false allegations against him were, and I quote, credible and true. Harvey Proctor was subsequently exonerated in Sir Richard Enrique's report and in the fulsome apology from the Metropolitan Police, and now in the incontrovertible evidence which is before this inquiry. Nonetheless, the burning injustice remains, and we are sure that it burns in other families and relatives of publicly prominent people whose names have been blackened. What should the inquiry do about it? The current answer appears to be not very much. Although he accepted the issues were important, Mr. Altman QC also said in his opening that there were principled reasons not to address in the Westminster investigation problems in the way cases of child sexual abuse are dealt with by the criminal justice system. He said that they are, and I quote, remote from the central purpose of this inquiry. With respect, this is the wrong approach. It is essential that the inquiry consider and make recommendations about the failings, particularly by the police, in Mr. Proctor's case. The inquiry's terms of reference include considering, and I quote, whether state and non-state institutions failed to identify such abuse and/or whether there was otherwise an inappropriate institutional response to allegations of child sexual abuse. It is right, of course, that the inquiry's central focus has to be on the endemic failure over decades to identify and prevent child sexual abuse. However, it must be the case that Mr. Proctor's treatment by the police was an inappropriate institutional response, to put it mildly. There are three principal reasons we say to inquire into the Metropolitan Police's actions in Harvey Proctor's case. Firstly, if the police fail in an investigation, particularly one of huge public interest, or are seen to be taken in by false allegations, they will reduce public confidence in their activities. This will deter people from coming forward with true allegations and cooperating with investigations in future. Secondly, failures cost money and resources which are necessarily drawn away from important investigations into child sexual abuse. Police specialists in child sexual abuse, as you have heard, are a limited resource and should only be working on investigations which are based on plausible allegations which can be corroborated. Thirdly, the inquiry can, by investigating this issue, make a useful and powerful contribution to the question of how police behave towards suspects in child sexual abuse cases. This is of profound interest and importance not just to those suspected of child abuse, but also to the genuine victims. And this leads me to my third and final submission, Chair and panel, namely that this inquiry should make recommendations to ensure that what has happened to Harvey Proctor is unlikely to happen to anyone else. In this regard, we respectfully make the following suggestions. The inquiry should hold a Westminster investigation Part 2. You have rightly steered clear of the issues around Operation Midland because of Carl Beech's forthcoming trial. However, you must return to the issue once the legal proceedings are concluded. Mr. Altman QC rightly identified that there are important issues over the police treatment of suspects, but also said they were generic rather than being specific to Westminster. It may be that the inquiry considers these issues under a separate investigation rather than a Westminster Part 2, but it must consider them nonetheless. In the further investigation, the inquiry should also consider the recommendations made by Sir Richard Henriques. We submit that it should approve them. We respectfully suggest the following recommendations as a starting point. Anonymisation of suspects. There should be real anonymisation of suspects of historical child sexual abuse before arrest. This means stopping the police practice of giving information which does not name a suspect, but in effect reveals their identity, such as in Harvey Proctor's case, where his age and location were revealed when his house was being searched, allowing the press to accurately guess his identity. Anonymisation before charge should also be considered. Police leaks. Every effort should be made to minimise leaks of information by the police. Sir Richard Henriques recommended examining current systems and increasing sanctions, and we agree with that recommendation. Search warrants. There should be transcripts of applications for search warrants, and they should only be granted in cases of historical child sexual abuse by district judges and not by lay justices. Complaints. Complaints to the police should be treated with the utmost seriousness and be investigated thoroughly. However, there should be no automatic belief of complainants, as this leads to errors such as were made in Harvey Proctor's case, where the allegations against him were publicly described by the police as credible and true before they could be corroborated. They never were. People should be called complainants until there is a confirmation by the criminal justice process that they are victims. Support for victims of false allegations. In exceptional cases where suspects have been falsely accused of a crime, they should be treated as victims of crime and should be offered support and liaison compatible with the gravity of the allegations made. We have a final suggestion which was not considered by Sir Richard Henriques. Much of the impetus for Tom Watson and the conspiracy theorists who approached him came from the fake news on the internet, namely, as you have heard, the Elm guest list, in which Harvey Proctor featured alongside other prominent people. You have heard from DCI Settle how this list of lies has no evidential value, but there it is, incredibly still up on the internet on several sites. You can Google it in an instant. Is there any way, short of ordering Google to remove it, that you can provide an antidote to this poison? We have an idea, and it's not an original one. It was developed by the Court of Appeal in the case of Lushansky, in the context of libel in newspapers. Instead of removing a libelous article from the newspaper website, a court can order that an explanation should be added to it, so that when downloaded again, the recipient would automatically and immediately be appraised of its falsity. We suggest that this would be in a proportionate and principled approach, which you should take, recommending that Google and other providers add the list appearing on its sites, words to the effect of "this list is of purported VIP guests has been investigated by police and found by the IICSA to have been fabricated by criminals and fantasists. There is no evidence to suggest that any of these persons ever attended the Elm Guest House." It may be that your recommendation will be ignored by Google, in which event Parliament may look into giving statutory powers to public inquiries to correct internet records. And we will be happy to provide further written submissions on recommendations should the inquiry consider this useful. In conclusion, Mr. Harvey Proctor wishes the inquiry well in its important remaining work. He thanks the Chair for making him a core participant, for giving him the opportunity to place on record his innocence of all these false allegations that have besieged him for the last 4 years. He commends all authoritative bodies that have investigated and agreed his innocence. He now places his highest trust in the Chair and panel that they will confirm his complete innocence unequivocally in their final report.
Thank you, Mr. Wagner. We'll now take our mid-morning break and return at 11:25. Mr. Steen.
Thank you, Chair. Chair, as you're aware, Tim Hulbert's evidence concerns 2 days of his working life as a dedicated public servant with 35 years in senior positions within social services. Between 1971 to 1977, Mr. Hulbert was employed as a Principal Officer for Community Services with the Leicestershire Social Services Department. And then later in 1977, Mr. Hulbert moved to the Home Office, the Voluntary Services Unit, the VSU. And he was there as a consultant with a civil service rank equivalent to a principal. When Mr. Hulbert worked at the VSU, he was shown a document by Alan Davis which set out a potential for future grant renewal of Home Office funds to various voluntary groups. One of those entries showed Home Office funds going to the Paedophile Information Exchange, P.I.E. And that was set out in an internal accounting record that related to the funding of the Women's Royal Voluntary Service, the WRVS, now the RVS. Mr. Hulbert and Mr. Davis joked about whether it could be that the WRVS was having a national bake-up. But that was a joke, as described in the cross-examination by Mr. Altman, that was akin to gallows humour. They were in fact both shocked and horrified. Mr. Hulbert knew from the press what P.I.E. was, and that it campaigned for the acceptance of paedophilia as a normal activity. So Mr. Hulbert told Mr. Davis that he would take it up with Clifford Hindley. Clifford Hindley was Mr. Hulbert's direct line manager. Clifford Hindley's rank was as an assistant, and in turn Mr. Hindley reported to the Undersecretary, Geoffrey de Denny. Mr. Hindley's role was as head of unit, deciding policy, recommending grants, and as an example, he was responsible for the oversight of grants to the WRVS and also for the Albany Trust. And he negotiated those grants personally. So Mr. Hulbert went to see Clifford Hindley and said something like, "Clifford, what the hell are we doing funding this outfit?" Mr. Hulbert explained to Mr. Hindley that it was illogical to be helping organisations in conjunction with the Department of Health that were promoting child protection and at the same time to fund an organisation which was campaigning to remove safeguards for children. Now, Mr. Hindley's response doesn't bear any other examination than as an explanation that P.I.E. was being funded. And he said these three important things to Mr. Hulbert. That P.I.E., the Paedophile Information Exchange, was a bona fide campaigning organisation, even if its objectives appeared to be objectionable. 2, that it was funded at the request of Special Branch. And you'll recall the small uncertainty in Mr. Hulbert's mind whether it's Special Branch or Security Services. Mr. Hindley explained that it was therefore useful to identify people with paedophile inclinations. And 3, that as this was an extension of a grant, it did not require the input of a consultant. There is no room for mistake here, or for confusion, or for any misunderstanding. The funding was for the Paedophile Information Exchange, and Mr. Hulbert was told to back off, and so he did. He has regretted that since this time so many years ago, and he thinks on reflection that if Miss Hartley Brewer, Callaghan's political advisor, had still been in post at that time, that he may have gone to her. Thereafter, Mr. Hulbert continued to work within the VSU until moving on to become the Deputy Director of Social Services for Hereford and Worcester County Council at the end of 1981. And he stayed in that post for 8 years until he was appointed as the Director of Social Services for Bedfordshire County Council. Mr. Hulbert's career has had many professional achievements. These have included the setting up of the first independent neighbourhood advice centre. We know all of these now to be called one-stop shops. That was back in 1969. He pioneered model contracts with voluntary organisations and set out the basis for what became a more wide franchising of local authority care homes. So we know that Mr. Hulbert is someone that has worked steadily and properly in the public interest. Mr. Hulbert's career was serious and considerable. He had serious and weighty responsibilities for the people under his care and the staff that worked with him and for him. He is not a frivolous man. He is not a lightweight, and he must be taken seriously. There is and there can be no suggestion that Mr. Hulbert was or is a publicity seeker or has any ulterior motive which could explain his recollection other than the fact that it is true. So how did his account come out at all? It was in 1994, when Mr. Hulbert was the Director of Social Services in Bedfordshire, that he was dealing with a problem of suspected abuse of children by staff in a children's home called Oxenden House. The Bedfordshire County Council established an independent inquiry and appointed Barbara Kahan, a well-known childcare consultant, to assist Mr. Hulbert. And Miss Kahan advised Mr. Hulbert to speak to the head of the Obscene Publications Squad, Superintendent Mike Hames, to establish whether any of the Oxenden staff members were known or suspected as abusers. And it was first of all then in a conversation with Superintendent Hames in 1994 that Mr. Hulbert told him of his experiences at the VSU regarding the funding of the paedophile information exchange. But in 1994, the BBC screened a programme titled The Secret Life of a Paedophile. Now, Mr. Hulbert was surprised, as he had not known, that Miss Kahan was shown in that programme to have worked with Mr. Wrighton, who was by then a known paedophile, but who had also been a senior social services advisor. After the programme, Mr. Hulbert called the BBC and left a message. I'm going to ask that this be put on the screen, please. It now has the relativity reference of PMK 000233. This message is, as we can see on the screen, to the effect that when Mr. Hulbert was a consultant at the Voluntary Service Unit, he had seen evidence that P.I.E. had been receiving Home Office funding. I read from this. P.I.E. was funded by the Home Office, says Mr. Hulbert, now Beds CC Director. Clifford Hindley, Head of Voluntary Service Unit of Home Office, was involved. And then it seems there's an attempt to set out where he might be found. There was no acknowledgement of this call to the BBC, and we can take the document off the screen, please. And it was not, therefore, until 2013 that Mr. Hulbert was called by David Tomes, the retired Director of Social Services for Hereford and Worcester. Now, Mr. Hulbert had been Mr. Tomes's deputy. Mr. Tomes said that he had been called by Peter McKelvey, who wanted to contact Mr. Hulbert about a phone call that Mr. Hulbert had made to the BBC in 1994. And we believe that the document we've just seen on the screen is the other side of that call, in other words, the message that was left at the BBC. We learnt that Mr. McKelvey told Mr. Hulbert they had come across a note of this call, likely to be the one we've just looked at, referring to the Home Office funding of P.I.E. Now, Mr. McKelvey had come across this note when he was helping David Perrin, the producer of The Secret Life of a Paedophile, clear up some old papers. So that's the chain of events that led to Mr. Hulbert's account and recollection coming out. Mr. McKelvey asked Mr. Hulbert whether he'd be prepared to speak to the police, Operation Fernbridge, and Mr. Hulbert agreed. But he told Mr. McKelvey that he wished to remain anonymous at that time. Now, on the 20th of November 2013, Mr. Hulbert spoke to D.I. Settle, and then 2 officers were sent to Mr. Hulbert's home to interview him. Now, as you'll recall from Mr. Hulbert's evidence, this wasn't a satisfactory interview, and Mr. Hulbert wasn't satisfied with the statement produced as a result. So we have the 2013 statement from Mr. Hulbert, the 2014 statement, a later one drafted by Mr. Hulbert, and the subsequent inquiry, ICSA inquiry statement. These statements have been the subject of the, how can I put it, the non-cross-examination by Mr. Altman. And that lengthy examination demonstrated, we suggest, that Mr. Hulbert's accounts were consistent in every material particular. And we challenge anyone to say that Mr. Hulbert was not an impressive and credible witness. Now, there was a time when we used to have a system of what were called old-style committals in criminal law. Now, what the defence lawyers would do with old-style committals would be to use that system to compel victims of sexual abuse and complainants to give their accounts on oath before magistrates. There were unpleasant reasons for this. One of the unpleasant reasons was to get another and very probably slightly different account to be used at a later trial. This is because when people give multiple statements, there will naturally be some differences. And you will recall that Mr. Hulbert said at the end of his evidence that although he is not a survivor, he now knows a little of what it feels like to be required to endlessly give their account time and time again. These sorts of multiple accounts become the meat and drink of cross-examination for lawyers like Mr. Altman and myself. We have between us over 60 years of experience of putting what are often small differences between accounts to witnesses in an attempt to shake credibility. But what we have seen from Mr. Hulbert is that he has time and time and time again explained that he saw a document that showed an application for a grant renewal for money to be sent to P.I.E. for a 3-year period to follow the original grant between what must be 1977 to 1980. Now that, as we know, is the only period of time that the Home Office records are missing. Parliamentary records fail to record it, and of course there are no WRVS, now the RVS, accounts to assist. But that's not all we know about this. In 2016, Mr. Hulbert and Mr. Davis exchanged emails, and they spoke on the telephone on or around the 23rd of June 2016. And can we have up on the screen, please, INQ 003974 at page 12. This is, in fact, Mr. Hulbert's statement, but as a matter of convenience, it contains the email he sent. In the email, as you have it on the screen, Mr. Hulbert says this, reflecting on the telephone call he had with Mr. Davis. In particular, it was your spontaneous response to my mentioning that I clearly remember a reference to WRVS brackets P.I.E., I think on the quarterly reference sheet for renewal. I've always regarded this as the most bizarre part of my recollection and wondered from time to time if my memory was playing tricks. When you said you remember that too, it hit me like a sledgehammer, because for the first time in this whole sorry saga, I had confirmation that my recollection was shared. Indeed, after 2 inquiries, found no evidence to corroborate what I know to be true, Without any prompting, you provided a key. I hope you don't mind, but I immediately pass this on to the inquiry lawyer, who is gathering the evidence together for this part of the Goddard inquiry, and he may get in touch. Let me then show you the response from Mr. Davis. INQ 003974, page 14. So same document, page 14. At the top of that page, you see it there. I hope this is of some use, but let me assure you that your memory is still very accurate. Now, let's just pause ourselves and reflect on what this email exchange means. You have it very clearly set out in the email from Mr. Hulbert, what he recalled not long after the conversation that he had with Mr. Davis. Is he a fantasist? You've seen him. No, he isn't. Is he someone that seems to have a predilection with making things up? No, that doesn't fit him either. Did he have some hold over Mr. Davis that would compel Mr. Davis to make this sort of response? No, that doesn't seem to fit either. So what do we have? The only sensible interpretation of this email exchange is that it is exactly as it says within the emails, a conversation that was recorded by Mr. Hulbert when matters were still fresh in his recollection of what had passed between the two, a discussion about what they had seen together back so many years ago at the VSU. Now, at some point, it may be said, perhaps by the Home Office, that Mr. Hulbert is mistaken. He's got it wrong somehow. Think about that with great care. Is this someone that could possibly have made this up, could possibly be mistaken about this? Does that make any sense to you as against what you know is this man's steady and serious work for so many years in the public interest? That suggestion, if it is to be made at any later stage, cannot be right, we suggest. Mr. Hulbert is exactly as he appears to be, a serious man from a serious career who has done his best as a public servant to help people and not to lead people astray. So Mr. Hulbert was aware from his conversation and the email exchange with Mr. Davis that Mr. Davis had information that could assist this inquiry, and therefore Mr. Hulbert contacted the inquiry to ask that someone contact him, as his concern was that Mr. Davis was quite ill and elderly. And we have a statement from Mr. Davis, dated the 19th of May. I won't ask for it to go on the screen, I'll just read out one part. Mr. Davis said this: I do, however, have a vague recollection, possibly in early '79, when a general conversation was about WRVS funding, when someone used the expression P.I.E. I cannot be sure, but I think it was Tim Hulbert. I only remember because of the acronym, as it wasn't something I recognised. And he said in that statement, I never gave it another thought. Now, of course, Mr. Hulbert's been surprised by the content of this statement, as it is so utterly contradicted by the telephone and email exchange that it had with Mr. Davis. Now, of course, Mr. Hulbert can't explain why Mr. Davis didn't tell the police or ICSA the truth. Was he worried about his pension? Was he confused? Was it his health? But even Mr. Altman, Queen's Counsel, has had to accept that Mr. Davis's recollection to the connection between a conversation about WRVS funding and P.I.E. provides some support for Mr. Hulbert's account. We now know that Wanless and Whitten review, Mr. Wanless and Mr. Whitten, Queen's Counsel's review, failed to interview Alan Davis. We suggest that this was a serious failure by that review. And it was one of the reasons why we were pressing, and probably being annoying, why we were pressing this inquiry to ask Mr. Wanless or Mr. Whitten to come forward and answer questions. In their place, Mr. Box appeared before you, now clearly doing his best from his recollection of what the documents were saying. But Mr. Altman, Queen's Counsel, we suggest quickly has demonstrated that Mr. Box was the wrong witness. As Mr. Box said in his statement, his duties were the duties of anybody assisting reviewers in this regard, but they included photocopying, indeed he referred to literally making the tea. He had no decision-making functions whatsoever. Mrs. May, when at the Home Office, wrote to Mr. Watson, MP, specifically about Mr. Hulbert's claims on the 25th of March, and said that the Wallace and Whitney inquiry did not have statutory powers that this inquiry, your inquiry, Chair, will do. And she said, Mrs. May said, that she was determined to get to the truth. Well, sadly, we suggest that this inquiry has missed an opportunity in failing to call Mr. Wanless and Mr. Whitten, Queen's Counsel. You know, Chair and panel members, from all of your work, that the ability to accept the single account of a credible witness is part of the law that has now been accepted, in particular in relation to complainants of sexual matters. The need for a jury to be warned about convicting a person on the uncorroborated evidence of that individual was abrogated, that's the word, within the Criminal Justice and Public Order Act 1994. This warning to courts to look for corroboration was seriously insulting and had been an obstruction to rather than a guarantee of justice in the past. But in this case, not only do we have the support from the evidence that we've examined regarding Mr. Davis, but there is also a wealth of background evidence that provides further support to Mr. Hulbert's account. Mr. Altman, Queen's Counsel, in his opening on the 4th of March said, searches have been conducted in Metropolitan Police Special Branch records, also in the records of Special Branch offices throughout the country. None of those searches have thrown up any documents which suggest that P.I.E may have been funded by the VSU, whether at the request of Special Branch or at all. However, he went on to say this, it seems that there was a Special Branch file opened on P.I.E in July 1978 that was destroyed in 1999 in accordance with their standard destruction criteria. And the crucial reference in that is the date, isn't it? Obviously also the fact Special Branch file destroyed. 1978, this is the very period of time that we're talking about, that Mr. Hulbert was told by Mr. Hindley that Special Branch was interested in and therefore wanting to keep an eye on paedophiles within the paedophile information exchange. The timing fits. During the course of evidence before you, Chair, from the anonymous security services witness on the 11th of March, we were told that MI5, I quote, was interested in P.I.E in the context of its counter-subversion. Originally, a proportion of founding members of P.I.E were active on the subversive left wing, and MI5 were interested in P.I.E being a possible vehicle for subversive activity. Now let's reflect on what was going on at this time in our history. This was at the peak of trade union activity. Union membership in the 70s going towards the end, passing the 13 million mark. Trade union legislation passed or being considered to regulate civic disruption. The Labour Party was in the hands of the left. Margaret Thatcher came in at this time, seeking to bear down on union activities and steer the country away from the left. It was not only a time of industrial conflict, economic decline and political extremism, but a period of violence. So, of course, left-wing subversive organisations were under the eye of the state. But this was also the time when P.I.E was infiltrating the NCCL, the National Council for Civil Liberties, had contacts with, and it seems, if I recall correctly, shared an address with Release, and was in contact with the Albany Trust. P.I.E was seen by some, as Clifford Hindley said to Mr. Hulbert, to be a legitimate campaigning organisation. That was in essence the attitude of the Albany Trust. Each time we look and learn a bit more, some other material services. Most recently, we've had correspondence from the security service MI5. And that says, I won't ask for this to go on the screen, I'll read out the quote. But so that you have the reference, it's HOM003243. I'll just read out the quote. That says that MI5 did have a file on P.I.E, but it never actively investigated P.I.E. What it was essentially doing was collating information that came to it from a variety of sources, some of it open source, in order that there was a corporate record relating to the organisation. So the file may have contained reports from Special Branch, but none of them have been selected for examination at this inquiry by the inquiry's legal team. And that, as it goes on to say, that it's now been looked at, and apparently that the author of this document, written by MI5 legal advisors, as it says on this letter dated the 18th of March, that has nothing to do with the inquiry's business. But does that adequately deal with the evidence that MI5 was interested in P.I.E in relation to subversive activities? We ask you to consider that question. Of course, we also know that it was during this period that the Obscene Publication Squad were pursuing their own investigations into P.I.E because of Peter Heyman, as described by Mr. Collins, the long-serving sergeant in the Obscene Publication Squad. But that's not all the evidence that relates to P.I.E. The account adduced by Mr. Clark from the Albany Trust shows how close the Albany Trust was to P.I.E at this crucial time. This is the same Albany Trust which was receiving funding from the VSU, funding controlled by Mr. Clifford Hindley, who knew and worked alongside Anthony Gray at the Albany Trust, as explained by Mr. Clark in his evidence. Now, Mr. Gray, from the evidence gone through by Mr. Altman, has been shown to be a clear supporter of P.I.E members in relation to some of their goals. Mr. Clark explained that from 1975 to 1977, he thought that that was the strongest possible time for the link between the Albany Trust and P.I.E. And that was the time which would have been just before the first grant in 1977, because what Mr. Hulbert saw was a potential renewal of this. In other words, that period of time, as explained by Mr. Clark, was 3 years before Mr. Hulbert saw the documents which suggested the renewal. And then we had the examination of Mr. Clark, going through the various documents, which showed a timeline that fitted the first grant from the VSU. As at that time, the Albany Trust was giving a warm reception to the idea such as I quote, a greater awareness of the sexuality of children. And there's also the reference to making children potential victims, not only adult paedophiles. Now, Mr. Clark suggested that the Albany Trust had sought to withdraw from its level of contact with P.I.E, but we know that that, in fact, continued. And Mr. Gray, even though he had left the Albany Trust, continued his own engagement with P.I.E. Mr. Clark described Mr. Gray and Mr. Hind in this way. He obviously accepted that they knew each other. In his evidence on the 26th of March, he described them as being figures of about the same age, with a similar sort of style of formality, respectability, and courtesy. It will be a matter for the inquiry, for you, Chair, and your panel members, to make what it wants of the published works of Mr. Hindley. The inquiry now has that material, and it's from his writings, which can only be regarded as sympathetic to pederasty, that we read you the quote as follows. This is from Mr. Hindley's published works. What I hope I have demonstrated, however, is an interest on his part, in reference to the person he was talking about, in history, on his part in right sexual relationships between older and younger men and boys. I'll read that again. Hindley saying, right sexual relationships between older and younger men and boys. Later on, he put it a different way. He refers to, again a quote, "It embraces love of body and love of mind, in which the older respects the younger partner and what he offers." You'll need to consider that evidence as much as the other evidence in this particular part of this inquiry. So what does all this lead to? Well, the fundamental purpose of a public inquiry is to rebuild and restore public confidence. Lord Laming, who carried out the Victoria Climby inquiry, told the British Select Committee on Public Administration that there can be little doubt that inquiries matter greatly to the public, especially those directly affected by the events under investigation. And for the government, the primary purpose of an inquiry is to prevent recurrence. It's also their view that the main aim is to learn lessons, not apportion blame. They believe that inquiries have helped to restore public confidence through a thorough investigation of the facts and timely and effective recommendations to prevent recurrence of the matters causing concern. Many inquiries have helped to bring about valuable and welcomed improvement in public services. So a fundamental purpose for this inquiry is to seek to rebuild public confidence in our political, police and security institutions. Chair, it is vital that you and your panel consider whether this investigation will achieve the restoration of public confidence in those institutions. And if you conclude that it does not, then you must take urgent steps to remedy this. Now, Chair, we say that you should find and should report that Mr. Hulbert told the truth. To find that he did see evidence that the Home Office or persons working within the Home Office had or had intended to provide substantial funding to the paedophile information exchange. You will, we suggest, find that because the Home Office review found it to be credible, as set out in a letter from your legal team on the 9th of March, having analysed the Wallace and Witten review. Your legal team said it this way: "We do not read the Wallace and Witten report as suggesting anything other than Mr. Hulbert had truthfully relayed his memory of the events in question." But most of all, you will make this finding because you personally observed Mr. Hulbert give his evidence over many hours under the careful examination of Mr. Altman, Queen's Counsel, an extremely seasoned prosecutor. Mr. Hulbert's evidence could not be shaken, undermined or disturbed in any material way because it was and is true, and we suggest you should say so in your report. But we recognise that leaves you and your panel in a difficult conundrum. Whereas we believe you will find that the Home Office or persons working with the Home Office did or intended to fund P.I.E, there is no corroboration that money, a money trail as an example, because of course records have disappeared, and there is no concluding part of the chain of evidence. So what do you do? What we suggest that you consider doing is this. You should be considering the question of what happens when a credible whistleblower comes forward and believably, credibly and truthfully says, "I've seen a danger to children," in circumstances where there may not be much else by way of supporting evidence. Now, if a man of the standing and credibility as Mr. Hulbert is ignored, then far fewer Tim Hulberts will come forward in future, and children will suffer as a consequence. We suggest that this goes to the heart of what you're about and what your investigations within ICSA are trying to do, and that is to establish the best possible system to protect children now and into the future. As a result, although we suggest you must find that Mr. Hulbert saw what he saw, what is more important is how that has been handled in the various reviews and this public inquiry. Whether a whistleblower is speaking from within a current institution or talking about events or evidence connected to child sexual abuse from the past, we need to understand, as it has been said repeatedly, that deference, fear, self-protection, loyalty, following, doing what you're told, within organisations are all factors that play their part. Now, time does not allow us to fully develop our proposals on encouraging, handling and protecting whistleblowers. We will do that in our written submissions. Can we summarise in this way? Employment legislation does not currently provide whistleblowing employees with some protection against retaliation, and what little it does provide is inadequate. It simply allows a dismissed employee to bring a claim against the employer for unfair dismissal. That's not enough. There must be a proactive structure in place to protect whistleblowers from the moment they make their disclosure. It is vitally important that whistleblowers know that they will be protected. Now, that clarity may be provided by mandating organisations with responsibility for the protection of children being required to produce a whistleblowing policy. And policies such as that must guarantee the whistleblower's protection. Restricting an organisation, as an example, and stopping it from relying on contractual gagging clauses or guaranteeing an anonymity where requested by the whistleblower. It must make and mandate that the organisation response to disclosures, including compulsory investigation and or outside reporting, must be dealt with properly and formally, and provide feedback to the whistleblower on the consequences of and the ongoing nature of the investigation of their disclosure. You may think that the establishment of a watchdog in this area to act as an oversight body for disclosures and for whistleblowers would be of assistance. So we support the introduction of mandatory reporting. This would have the benefit of protecting whistleblowers. The law must provide or must require professionals with responsibility for children, including civil servants, to make a disclosure of any reasonable suspicion that a child is at risk of abuse. Currently, the legislation in dealing with whistleblowers within the intelligence services and the military has an exception. That needs to be thought of and looked at with care. Obviously, there is a difficulty when dealing with such institutions as the intelligence services and the military, but it needs to be looked at with care in order to establish that the need for protection is the protection of children and nothing else. Chair, we suggest that you will find that Mr. Hulbert told the truth and then go on to grapple with the consequences of that finding by making recommendations as regards whistleblowers that will ensure that other Tim Hulberts come forward in the future. Thank you.
Thank you. Ms. Leake.
Chair, members of the panel, I make this a brief closing submission on behalf of the Commissioner and the officers who've been here during the course of the hearing. During the course of this investigation, the inquiry has heard evidence about allegations of wrongdoing by police officers and others connected with allegations of child sexual abuse by persons of public prominence connected to Westminster. I remind you that the allegations were into police misconduct and not into the underlying allegations of criminals, as suggested by Harvey Proctor's counsel. Those allegations of misconduct have been investigated by the Metropolitan Police Service, either locally or managed by the Independent Office for Police Conduct. Chris Mahaffey described the process in place between Operation Winter Key and the IOPC as being, and I quote, collaborative but intrusive and challenging. We also invite you to note Mr. Mahaffey's evidence on day 2 that the investigators made every effort to interview everybody named by the person making the initial allegation. Operation Winter Key followed the evidence of potential police misconduct wherever it took them. Chair, you and the panel can and should have every confidence in the processes adopted. As Commander Roper put it, investigators explored every allegation that was brought to the MPS, even if the allegation provided very little information about the alleged wrongdoing. We invite you to consider the 17 matters which were investigated by the Metropolitan Police Service and the very low threshold that has been applied. Commander Roper, together with other officers from Operation Winter Key, has been present throughout the 3 weeks of evidence. She, and they, and we, have paid particular attention to the evidence of those former police officers who gave evidence about their experiences, and in particular, their accounts that investigations were stopped prematurely. As she and Mr. Mahaffey explained in the witness box this week, the Metropolitan Police Service and the IOPC will now review the evidence that has emerged during the course of this inquiry, as she promised, and consider whether there are further lines of inquiry to be explored, and whether, for example, Operation Beach should now be revisited. The Metropolitan Police Service has invited and indeed welcomed critical examination of its involvement with the matters connected to this inquiry's investigation. What can be said now, and we invite you to find, is that insofar as any person or organisation is inclined to suggest that the IOPC and or the Metropolitan Police Service has whitewashed the allegations made, any such suggestion can and should be rejected. Such a suggestion is wholly without evidential foundation and plainly wrong. May I turn briefly to emerging themes? Earlier this week, Commander Roper, along with Mr. Mahaffey, gave evidence about the overarching themes which emerged from the first weeks of evidence. One of those themes was whether officers historically showed undue deference to more senior officers or to members of the establishment. You will recall Commander Roper's evidence to you on this. She was clearly unable to comment personally on the culture of the 60s, 70s and 80s, save by reference to the evidence provided to Operation Winter Key. Chair Mr. Scorer said that Catherine Roper denied that there had been a significant culture of deference. In fact, if my recollection serves me, she was extremely careful to comment only on the evidence that she had seen and heard, as is entirely befitting, you may consider, for an officer in her position. However, she was able to give evidence about how the culture within the Metropolitan Police Service now encourages, indeed requires, officers to challenge inappropriate behaviour by their senior officers. From the evidence given by former officers and by Commander Roper, it is absolutely clear that the internal communications and the hierarchical structure and ways in which teams worked within the Metropolitan Police Service were a world away then from how they operate today. As for deference to people of public prominence, the Metropolitan Police Service has no intention to be defensive. However, we would also caution against inferring a police-wide culture from the evidence you have heard concerning Neil Diver and one or two other senior officers who may have had vested interests and who have not been able to account for their actions. Chair Mr. Scorer created an entire scenario around a snippet of conversation, including the Prime Minister and the Commissioner. We ask you only to make findings on the evidence that you have actually heard. Chair, one of the striking issues which has been drawn out from the various IOPC and Metropolitan Police Service investigations, their closing reports and the evidence heard in this inquiry, is how a lack of communication might have fostered and engendered concerns that inappropriate action was taken. This lesson has not been lost on the Metropolitan Police Service, and a more comprehensive regime of debriefing officers involved in major inquiries now exists. It is likely that improvements can still be made in this area, however, and consideration will be given to those. The inquiry heard evidence from Don Hale. We do not propose to address the substance of Mr. Hale's evidence, namely whether members of Special Branch attended his offices and seized a dossier provided to him by Dame Barbara Castle, listing the names of individuals connected to P.I.E. This matter has been examined during Operation Hawthorne, an IOPC-managed investigation. Having listened very carefully to Mr. Hale's evidence, we do not, however, see any basis to doubt the conclusion of the Operation Hawthorne closing report. You may conclude, Mr. Hale's account having been exposed to forensic scrutiny for the first time, that there are serious questions over the fundamental accuracy of his account. In evidence, Mr. Hale made a number of very serious allegations about the process adopted in taking his statements in 2014 and again in 2017. He criticised both the MPS and the IOPC in the way in which Operation Hawthorne was conducted and the conclusions reached. We take those allegations very seriously and will consider with the IOPC whether a further investigation is warranted. We will keep the inquiry updated. However, at this stage, we seek to make only a few brief observations. First, you will recall that Mr. Hale raised concerns that manuscript amendments and deletions made to his 2014 statement were not reflected in the typed version provided to the inquiry. The manuscript copy was located and disclosed. There are no material differences between the two. The only differences are minor typographical errors. Mr. Hale was invited to review the manuscript version alongside the typed version. We have recently seen his response. Any criticism is plainly ill-founded. Second, you will recall that Mr. Hale objected to the non-inclusion of relevant information contained within 46 emails passing between himself and a police constable attached to Operation Winter Key. The emails are in the main of little relevance. Most concern practical arrangements to meet and take Mr. Hale's statement. What is clear from those emails is this. A copy of the typed 2014 statement was provided to Mr. Hale at his request. Mr. Hale was asked to, and did sign, 2 further statements. They were sent as editable documents. Those statements were examined during the course of his evidence. He signed both of them. The panel will be familiar with the declarations accompanying those statements. Third, as to Mr. Hale's criticism that the IOPC and MPS proceeded on the erroneous basis that a cleaner was or may have been present during the course of the alleged raid on his office, we invite the inquiry to note the contents of his signed 2014 statement. As to the alleged errors in the closing report, we simply point you to the text of the report itself. On any objective reading, the report accurately reflects the information provided by Mr. Hale. Whilst the MPS proposes to look into these matters further, on the basis of what we have seen thus far, there appears to be little basis for criticising the police constable who took the statements. Elm Guest House. Prior to this inquiry, volumes have been written and published about the Elm Guest House, much of which has concerned allegations of police wrongdoing. However, as Commander Neil Jerome explained in his evidence, and as we set out in our opening statement, there is currently insufficient evidence to substantiate any allegation of misconduct in the way in which officers dealt with allegations of child sexual abuse. Nothing that has been heard over the past 3 weeks casts any doubt upon that conclusion. Chair, I do not wish to respond to Mr. Proctor's counsel's speech, save to say that you are invited by Mr. Wagner to find that Mr. Proctor has been exonerated and cleared. May I simply refer you to paragraph 7 of your determination with regard to his application for core participant status. Chair, you said this: the basis on which I grant this application is that the inquiry will, in the course of investigating the conduct of a number of historic police investigations, hear evidence of allegations of sexual abuse that have been made against Mr. Proctor. This evidence will not include the allegations made by Col Beach that led to Operation Midland, but will include, as Mr. Proctor's application anticipates, allegations connected with Elm Guest House. I emphasise, as counsel to the inquiry has made clear, at both of the preliminary hearings referred to above, that in this investigation, the inquiry will not be seeking to establish the truth or otherwise of allegations of this nature. But I do accept that the fact that these allegations will be aired gives Mr. Proctor a significant interest in the investigation, which justifies granting him core participant status. Chair, you then said this: I should add for completeness that Mr. Proctor's application asserts that he is entitled to CP status on a number of other grounds. I do not find the other grounds persuasive. For example, Mr. Proctor asserts that he has a significant interest in the matter to which the inquiry relates, namely the paedophile ring in Westminster Dolphin Square, of which he is alleged to be a member. You gave a number of other examples, and you went on to say this. Counsel to the inquiry made it clear at the October 2018 preliminary hearing, as recognised in other sections of Mr. Proctor's application, that the Dolphin Square paedophile ring allegations made by Cole Beach will not form part of the Westminster investigation. You then said, Chair, for these reasons, the submissions that I have cited above do not raise issues that fall within the scope of the investigation and therefore do not take Mr. Proctor's application any further. But, Chair, what you have heard evidence in relation to is allegations of police misconduct, which I have dealt with, not, as I have specified, allegations of of underlying criminality. Chair, finally, may I briefly address one discrete matter which was raised by Mr. Frank during questions of Mr. Mahaffey and Commander Roper. And this concerns the policies for the retention of data. This is not a subject upon which the inquiry has invited evidence. If it would assist, further information can be provided. Alternatively, the inquiry may feel it appropriate to address this in one of the other investigations in which the Metropolitan Police Service is a core participant. What I can say at this stage is that the policies concerning the retention of data by the Metropolitan Police Service and other police forces are complex and subject to, amongst other things, statutory guidance provided by the Secretary of State, the Data Protection Acts of 1998 and 2018, and the GDPR. To complicate matters further, Chair, this is also an area in which there has been a considerable amount of litigation, including cases against the Commissioner, which have gone to the Supreme Court and the European Court of Human Rights. Chair, on behalf of the Metropolitan Police Service, we have sought to provide all possible assistance to this inquiry. The Met has disclosed to you and your team many thousands of pages of material. We hope that the process of examining this material, including through the careful questioning of witnesses in this forensic environment, will contribute to the public understanding of what has happened in the past. As an organisation, the Metropolitan Police Service is committed to learning whatever lessons for the future can be drawn from that history. Thank you.
Thank you, Ms. Leake. Ms. Skinner.
Chair, members of the panel, I make this brief closing statement on behalf of the Independent Office for Police Conduct, the IOPC. As you are aware, the IOPC oversees the police complaint system in England and Wales and has a statutory duty to secure and maintain public confidence in it. The IOPC also investigates death and serious injury cases and certain conduct matters. A conduct matter being where a complaint has not been received, but there is an indication that a person serving with the police may have committed a criminal offence or behaved in a manner which would justify the bringing of disciplinary proceedings. The IOPC is, as its name suggests, independent of police, of government, and of interest groups. Since January 2015, the IOPC has been responsible for 37 investigations that broadly relate to allegations of police misconduct associated with allegations of child sexual abuse involving persons associated with Westminster, and which concern the Metropolitan Police Service. By the time that the inquiry came to hear evidence, 32 of those investigations had concluded, and the remainder were near finalisation. Final or draft closing reports had been prepared for each. On day 2 of the inquiry, the 5th of March 2019, the inquiry heard evidence from Chris Mahaffey, the lead investigator at the IOPC, as to the extensive work that has been undertaken in this regard by it in conjunction with the Metropolitan Police Service's Operation Winter Key. The inquiry has adduced into evidence an overview report prepared by the IOPC. The IOPC prepared this report in order to provide a comprehensive explanation of the investigations, the manner in which the IOPC and the MPS has progressed them, the difficulties that have been encountered, and the general findings and themes emerging. The IOPC produced this document in order to provide the inquiry and the public with a detailed understanding of its work in this regard. That report is now available on both the inquiry and IOPC websites. Mr. Mahaffey provided evidence on a number of the issues addressed in the overview report and provided more detailed evidence in respect of several of the investigations. As the inquiry is aware, almost all of those investigations concluded that there was insufficient evidence to support allegations of police misconduct. The IOPC fully appreciates the frustration that this will have caused to a number of people and wishes to publicly reaffirm its commitment to ensuring that allegations of police misconduct are dealt with appropriately and fully in accordance with the statutory scheme. Representatives of the IOPC have been in attendance throughout the hearings of this strand of the inquiry. They have listened carefully to the oral evidence and have also been considering the disclosure provided and the written evidence adduced. The IOPC has from the first been keen to ensure that its work is sensitive to that of the inquiry and that it responds appropriately to any new evidence or allegations that fall within its remit. Now that the evidence has concluded, the IOPC will, as Mr. Mahaffey said earlier this week, conduct a review of that evidence with a view to identifying potential further lines of inquiry and determining whether any of the investigations should be reopened or new investigations instigated. The IOPC will, of course, keep the inquiry updated as to its progress in this regard. The IOPC notes the evidence that has been heard in relation to changes and improvements that have been made, both within the police, for example, the mechanisms of accountability, and more widely across our society. Whilst the IOPC is somewhat assured by this evidence, it is also clear that there is no room for complacency. The IOPC will endeavour to robustly discharge its statutory duties in order to play its part in ensuring that this progress is continued. The IOPC will also reflect upon whether there are any matters of organisational learning that it should consider in respect of how it approached these investigations. As an organisation, it continually seeks to learn and improve and wishes to maximise this opportunity to do so. This is particularly important here in view of the subject matter of this inquiry.
Thank you, Ms. Gill. Ms. Johnson.
Chair, panel, you are scrutinising prosecutorial decisions to determine whether there is any evidence that there was an establishment cover-up of paedophilia. In the 1970s, in serious or sensitive cases, the decision to prosecute or not was made in the DPP's name. Although semi-detached from Westminster, the DPP was clearly a member of the establishment, if what is meant by that term is an elite holding positions of power. As will be immediately obvious, the two cases which the CPS were asked to address in this inquiry predate the birth of the CPS in 1986. So we are here to assist you with the decisions made by the DPP's office insofar as we can. The role of the DPP began as a result of the Prosecution of Offences Act 1879, and the regulations set out the criteria for referring a case to the DPP. Any offence punishable with death, any case referred by another government department, and any case of importance or difficulty, or which for any other reason required his intervention. In addition, there was a list of specific offences which had to be referred to the DPP. Interestingly, it did not include sexual offences against a child unless it involved the communication of a venereal disease. And this, we suggest, provides a revealing insight into how child abuse was recorded at that time, and indeed extending right into the 1970s. In the Montague and Hayman cases, the DPP was involved because the case was of importance or difficulty. Importance probably being the trigger for referral. And it was of note that Mr. Collins told you that all the obscene publication cases went to the DPP. So Hayman's case would have landed on the DPP's desk, irrespective of his position in society. So let's examine those two cases, beginning with the Montague decision. Montague was accused of indecently assaulting a 10-year-old boy who lived with his family on Lord Montague's estate. The offences occurred between 1970 and 72. The indecent assaults took place under the guise of play fighting, during which Montague kissed and touched the boy's genitalia and placed the boy's hand on his penis. Now, the report which Mr. Altman, Queen's Counsel, took you to in short form, the report prepared by Detective Chief Inspector Newman, is, we suggest, highly instructive. He is not a member of the establishment. Nowhere in his very full report does the word abuse appear. Instead, the boy is believed to be, and I quote, in moral danger. The boy is described as, I quote, a simple lad, perhaps to be pitied. The boy's mother is described as having an animal-like approach to life. Lord Montague is spoken of very highly as an employer and a friend, lonely, and his interests in the boy deemed to be no more than fatherly. That police report demonstrates the fundamentally different approach to child sex abuse in the 1970s. In a society riddled with class distinction and behaviour which was assessed on grounds of morality rather than criminality, the real offending was lost. Montague was cautioned. The DPP's office note of the decision describes it as a borderline case. Now, what seems to have tipped the balance was Montague's previous good character at the age of 66, and that there was no fear of repetition with the boy in question. So the decision to caution indicates that there was sufficient evidence to prosecute, but one has to infer that it was not considered in the public interest to proceed. That public interest, we suggest, is what is being described as borderline. It appears that in 1972 there was no guidance in relation to the public interest test, or indeed the criteria by which to administer cautions. The factors which should be taken into account when assessing the public interest test were only set out in writing in the first edition of the Code for Crown Prosecutors in 1986. So 14 years after the Montague decision, that first edition of the Code stated that insofar as sexual offences against children was concerned, and I quote, there will seldom be any doubt that prosecution will be in the public interest. Now, as Mr. McGill told you, there is no benchmark available now to judge adequately the decision made in Montague's case at the time. And we suggest, given that, one cannot go so far as to say that it was wrong. However uncomfortable one might feel about it, it is clear that in 1972 the discretion was wide and the public interest concept was nowhere near as sophisticated as it is now. Today, there is no doubt that the case would be prosecuted. There are various factors which would point to prosecution: the age and vulnerability of the complainant, the disparity in age, the abuse of trust, the grooming, and the number of indecent assaults. And panel, it is interesting to note that the same factors which tipped the balance away from prosecution in 1972 would tip the balance towards prosecution today. By way of example, the fact that Montague was 66 years old and an excellent employer of the boy's father tended against prosecution in 1972. But those features would be seen as a gross abuse of trust today and tend towards prosecution. The Hayman decision. In 1978, as you know, the police found volumes of obscene correspondence at a flat occupied by Hayman, and in addition, a briefcase was left on a bus which contained further obscenities, and that briefcase, we know, belonged to Hayman. There was no evidence of any sexual offences against children, and insofar as we can tell, although one has to treat this with a degree of caution, the photographs of children were not indecent or obscene. It is clear that Hayman grotesquely described his fantasies, but Mr. Collins told you that he could not charge Hayman with any sexual offence against a child. And so the suggestion made by Mr. Scorer that the DPP had a dismissive attitude towards child abuse needs, we suggest, to be treated with a degree of caution. As you know, the police report written by Mr. Collins asked the DPP to consider a prosecution of Hayman and others for offences against the Post Office Act. Jeremy Norton was a lawyer working in the DPP's office, and he provided a note concerning the matter. It was necessarily a provisional view, as Mr. Norton did not have the authority to make the final decision as to charge or not. And on reading that note, again, it's clear that the DPP's office did consider whether any substantive offences against children had been committed and concluded that they had not. As to whether there should be a charge of sending obscene material through the post, the DPP's office bore in mind that the offence was outdated. The section was designed to protect post office employees who in this instance had not been harmed. The material was circulated amongst a group of like-minded adults, and there was no intention to make a financial gain. Now, you may conclude that the testimony of Mr. Norton, as set against his contemporaneous note, were inconsistent. For example, the note suggests a disinclination to prosecute, whereas Mr. Norton told you that he was progressing towards a prosecution. Mr. Norton said that the public interest didn't come into it, and he was considering whether there was sufficient evidence. But clearly there was sufficient evidence because the DPP ultimately chose to offer a caution. And so we submit that given the conflicting evidence, the fact that you do not have the record of the DPP's decision, and the lack of any policy or guidance applicable at the time, again, it would be unsafe to condemn the decision to caution outright. Having said that, there is no evidence that the DPP's office considered a possible prosecution of publishing obscene material, contrary to Section 1 of the Obscene Publications Act 1959. Now, that offence should have been considered. It's impossible to suggest what the outcome may have been without sight of the material generated by the investigation. One aspect which clearly does raise alarm bells is the evidence that Sir David Napley went to see the DPP about Hayman's mental health. Now, although his health would be a material factor, any defence submissions should always be in writing and, as you heard, with accompanying evidence. And one can imagine that less well-known solicitors with less well-known clients would not have been afforded the same access to the DPP. Whether such meetings were usual or not in those days, it's impossible to say. But clearly, such a meeting is to be decried. However, that meeting does not demonstrate a cover-up. A provisional decision had already been made before the meeting occurred. The meeting is perhaps indicative of the influence of the Old Boys Network. That was perhaps what was underlying Mr. Collins' testimony about that. That would never be permitted to happen today. The CPS will always ensure that proper professional boundaries are kept and everything is transparent. As the evidence stands now, it is unclear whether Wardle and Sewell were prosecuted under the Post Office Act. As you've heard, further inquiries are to be made. As Mr. McGill said in evidence, each case would be looked at on its own facts. And so at the moment, whilst we await those further investigations, we suggest that one cannot go so far as to say that there was one rule for the prominent and another rule for the ordinary man. Moreover, there is conflicting evidence about whether there was a disagreement between the Attorney General and the DPP concerning Hayman. On the one hand, you have the Daily Mail Beast of Berlin article that stated that DPP's aides were disgusted by the decision not to prosecute. On the other hand, you have Sir Thomas Hetherington's note in the Cabinet Office files stating that there was no such disagreement between him and the Attorney General. Perhaps you cannot take that strand of evidence very much further. Moreover, as to Hayman asserting to MI5 that he had been given immunity from prosecution by the DPP, well, there's no evidence of that. And as the MI5 witness told you, it makes absolutely no logical sense. Of course, that witness was a lawyer. And you may conclude that Hayman is not a reliable historian, particularly in his own cause. In our submission, there is no evidence that these two prosecutorial decisions go anywhere near to demonstrating improper interference in the process. Some people may not like the decisions made, but that does not prove improper interference. And as well as inquirers, you also have to be cultural historians. What these two cases do demonstrate is an approach to child sex abuse and the public interest test, which are wholly discordant with our approach today. By examining these two cases, we suggest you can be confident about how quite far the law and the prosecution authority have come. In the 1970s, the interests of the victim were given insufficient weight. Today, the interests of the victim are given proper weight at all stages of the prosecution process. Mr. Altman, Queen's Counsel, in his opening remarks, asked whether the decisions demonstrated undue deference. Deference to who? Deference to what? It was an age of deference, but it was also an age when victims' rights were not at the forefront of decision-makers' minds. And we suggest it is impossible for you to disentangle those two elements? Put another way, how can you safely conclude that these decisions were taken because the accused were members of the establishment? Or is it equally likely that the decisions were taken because at that time a defendant's interests were placed above those of a victim's? Moreover, don't forget that after the Hayman decision, he was subsequently prosecuted for importuning, which rather negates the idea of him being protected by the DPP because he was a member of the establishment. So in conclusion, it is submitted that the evidence is incomplete and inconsistent, particularly in the Hayman case, so that you cannot be satisfied that there was either interference in the decision-making or undue deference to those in authority. But what you can be satisfied upon is that the rights of child victims were almost ignored in the 1970s. And what you can further be satisfied upon is that now both those cases would be prosecuted because the rights of the victims are at the forefront of prosecutorial decision-making. Thank you.
Thank you, Ms Johnson. Mr Griffin.
Chair, panel, thank you for the opportunity to address you now. I would like to make some headline points, and we will follow those up with a written closing in short order. I'd like to cover over the next 10 minutes or so the Home Office and other government departments, how they have interacted with this investigation, the P.I.E. issue, and also the honours system and safeguarding. The Home Office and government more widely have been and are absolutely committed to assisting the inquiry in this investigation. They've made substantial disclosure to the inquiry. They've made substantial disclosure to the inquiry for the purposes of the investigation. And you have, by way of an example, the liaison that the Home Office undertook to get information from 21 central government departments about their safeguarding policies to you so that Professor Thoburn could consider them and provide her conclusions. You've had witness statements and heard evidence from Home Office witnesses concerning the Wanless-Whittam review and covering safeguarding. And if you want to have an example of the extent to which this inquiry has gone to get to the truth and the extent to which government has cooperated in that task, you just have to look at the fact that you have received statements from MI5, MI6 and GCHQ, and you've heard from witnesses from 2 of those locations. So turning first of all to the issue of the paedophile information exchange, and one of the key issues being considered by the inquiry in this investigation in relation to P.I.E. is the suggestion that the organisation may have been funded by the government. That suggestion was made by Mr Hulbert, and it relates specifically to the Home Office's Voluntary Services Unit. Today I would like to consider the suggestion that has been put in this way. First of all, that the VSU was funding P.I.E. Secondly, that P.I.E. may have been funded through the VSU's payment to the WRVS. And thirdly, that this may have been in order to aid the security services or special branch, both terms have been used by Mr Hulbert, as part of an effort to infiltrate P.I.E. This inquiry is the 3rd occasion on which at least certain aspects of that suggestion have been considered. And the situation is that each review has built on the work of the review that preceded it, to the extent now that we have an inquiry with greater resources and greater time, which has received even further information about this issue. And the further information that has been received covers various different areas, but they include about the VSU and its funding. They include about the WRVS, including its P.I.E schemes and funds, and that's an issue that I will return to shortly, and about Special Branch and the Security Service. You've had the benefit of a further statement from Mr. Hulbert, in which he has provided his most up-to-date thoughts about these matters. And perhaps most importantly of all, you've heard Mr. Hulbert's oral testimony under questioning by counsel to the inquiry, Mr. Altman. So where has all of that taken us? The panel may now think that it is possible to reach conclusions that Mr. Hulbert is genuine but mistaken in his various recollections, and that the suggestion about funding via WRVS can be ruled out as a reasonable possibility. There are a number of relevant factors to consider, and we will cover those in the written closing statement, but some of them are these. First of all, the inherent improbability of what Mr. Hulbert has suggested. It is an odd and unnecessarily complex way to pursue a desire to infiltrate P.I.E. That was the wording from the Wanless-Whittam review. And it would indeed be strange to use a cover organisation, such as the WRVS, and then fail to conceal in accounting the reference to P.I.E. There are real difficulties with Mr. Hulbert's evidence. The inconsistencies between his various accounts, about which you have heard in detail, and the improbable suggestion that his memory has improved over time from hazy to certain in respect of some of the most important aspects of what he has to tell you. Following extensive checks, no evidence has emerged to corroborate his suggestion, but there is, unfortunately, strong evidence which undermines it. And the evidence of Alan Davis is a good case in point. Mr. Hulbert suggests in his most recent statement that during their time in the VSU, Mr. Davis pointed out an entry on a sheet which read WRVS and then in brackets the acronym P.I.E. It was shown as a grant for renewal in the sum of what Mr. Hulbert thought was £30,000. And yet Mr. Davis's own statement to the police in 2014 and to this inquiry in 2017, and so after the email exchange between Mr. Hulbert and Mr. Davis that you've heard about, do not support Mr. Hulbert's recollection. Neither the Metropolitan Police Special Branch nor Regional Special Branch provide support for Mr. Hulbert. On the contrary, there's nothing to suggest they were ever tasked in relation to P.I.E. or sought government funding to sustain P.I.E. to aid their infiltration of it. And similarly, you now have evidence from the Security Service, and that is that it never actively investigated P.I.E. And it has recently confirmed that no records have been found to suggest that Special Branch liaised with or updated the Security Service about P.I.E. I'd like to turn just to consider briefly the contemporaneous documentation that you now have. We do now have VSU funding figures for the WRVS throughout the period of particular interest from 1971-72 to 79-80. In a couple of cases they are estimates, and in fact we have figures for years after that as well. The evidence we have also about Mr. Hindley is that he took his responsibilities as head of unit for the VSU seriously. The documents do not suggest that he would have condoned the use of the WRVS to channel funds to P.I.E. They demonstrate that he was in fact concerned that the WRVS should properly be reviewed during the time in question. And you may recall some of the questioning that counsel to the inquiry put to Mr. Hulbert about certain documents from the end of 1980. There is one in particular which shows that in November, so right at the end of the year, Mr. Hindley had asked Mr. Hulbert to provide a note on the reasons for conducting a WRVS review. And Mr. Hulbert provided that note on the 19th of December 1980. This was on any of the views, any of the versions of events that we've heard about from Mr. Hulbert after he would have seen the document showing WRVS and P.I.E. So it is significant that Mr. Hindley is asking that a review be conducted precisely on that organisation, WRVS. And we have the response from Mr. Hulbert. He identified 6 primary reasons and 9 secondary reasons why a review should be conducted. None of them had anything to do with funding of P.I.E, and none made any suggestion of impropriety. You've heard for the first time this morning from Mr. Hulbert's counsel about articles written by Clifford Hindley. These are articles from the 1990s, I understand, for journals such as the Musical Quarterly, the Classical Quarterly, and similar types of journal. And they cover issues such as Benjamin Britten. They are utterly irrelevant to the issues you must consider. There is also no evidence to suggest that P.I.E received funds from the VSU. On the contrary, the evidence is that P.I.E was short of funds during the period in question. Given all of this, the panel may wish to consider whether Mr. Hulbert has in fact become confused over time. And on Mr. Hulbert's own evidence, it's 15 years that elapsed between his seeing the document and first referring to it, and then about another decade between the BBC phone message and interaction with reviews and inquiries. Given all of that, the possibility is that he has become confused. It may not be necessary for you to decide how the confusion has arisen, but documents now disclosed by the RVS may provide an answer. I'm going to ask that a document be put up on the screens, please. It is RVS 502 at page 062. Yeah, 5 zeros followed by 2. And then page 62, please. Could you highlight or expand the title in the first paragraph, please? So here we can see a document from the late 1940s, WVS P.I.E scheme, Northamptonshire, and the WVS Rural P.I.E scheme operated in Northamptonshire from 1942 to 1945, and it goes on to say that it resulted in a magnificent profit of over £30,000. And so what we have here is a document that shows WVS, the Royal, hadn't been added to the title yet, in conjunction with the word P.I.E, and it even mentions a figure of £30,000. Now, Mr. Hulbert suggests that he would not have seen documents such as this, or indeed other documents concerning the WVS P.I.E schemes and funds. And that's a matter you will have to consider. But it is possible, I suggest, that some discussion within the VSU about the WRVS during Mr. Hulbert's time there, or something he learnt later, may actually have been about WRVS P.I.Es and not P.I.E. And this may have led over the years to Mr. Hulbert's confusion. As I've said, the panel may think it's now possible to reach conclusions that Mr. Hulbert is genuine but mistaken, and that the P.I.E. WRVS suggestion can be ruled out as a reasonable possibility. I'd like to move on then to the honours system. The investigation has considered concerns about honours granted to individuals who've been accused of child sexual abuse or where allegations of this nature were made after the honour had been granted. The inquiry heard detailed evidence about the honours system, past and present, from Helen McNamara, Director General of Propriety and Ethics in the Private Offices Group in the Cabinet Office. It's right to say that the spotlight on past events has shown that in certain cases wrong decisions were made and that processes were not sufficiently robust. Changes have since been made. As you heard, the operation of the honours system is very different today than it was during the period in the 1980s of particular consideration by the inquiry. However, it is recognised that there will always be room for improvement, and the Cabinet Office welcomes the inquiry's views and any recommendations it may wish to make. Safeguarding. The Home Office and other government departments welcome the report of Professor June Thoburn and the thoroughness with which she approached her task of reviewing the safeguarding and child protection policies and practices of 21 government departments. Professor Thoburn found instances of good practice in all government departments. She gave oral evidence that every department had something to commend it. But she also identified areas for improvement. Government departments are grateful for the clear and practical nature of Professor Thoburn's recommendations as set out in her report and summarised in her oral evidence. They are considering them carefully, as they will, of course, any recommendations that the inquiry makes in due course. In conclusion, the Home Office and other government departments and bodies remain committed to assisting the inquiry to arrive at the truth in this investigation and to provide it with the information it needs in order to make recommendations for the future. They are engaged with this process and await the panel's findings and recommendations with interest. Thank you very much.
Thank you, Mr. Griffin. We'll now break for lunch and return at 2 p.m.
Thank you, Chair, members of the panel. I'd like to make a few observations on behalf of the Labour Party on the following topics. First, Mr. Peter Morrison MP. Secondly, the role of the whips. And thirdly, current practice and procedures on the safeguarding of children. Madam, given the time constraints, this will be necessarily broad brush. We will file written submissions with the evidential footwork, as it were, the footnotes to what I'm saying now. So firstly, Mr. Morrison, the suggested involvement of the Labour Party or its members is, we think it would be fair to say, on the margins or the outskirts of any issues about Mr. Morrison's sexual conduct or possible criminal misconduct and how police or his party responded. And I won't comment in these submissions on the proper role of the police and the issue of whether or not there should have been an investigation into the rumours that you've heard of. But with regards to his party, to put it at its most basic, Mr. Morrison was a Conservative Party MP, and the first line of defence within Westminster should have been the actions of his own party, assessing if he posed a risk to children and taking action if needed, if information on these issues was brought to the party's attention. Furthermore, there is no suggestion in this inquiry that any Labour Party member or activist had any first-hand or new information about Mr. Morrison's activities or any misconduct that was not already widely known and in particular known to the police. It was all second-hand rumour. This isn't a case in which individuals knew something new but didn't share it. Rumours had, it seems, circulated for the better part of the 1980s. And this is relevant, Madam Chair, to any suggestion of an agreement if Mr Morrison stood down in the late 1980s. It seems that gossip was rife about Mr Morrison from an early period in the 1980s. The evidence of Ms Russell on this was confirmed by witnesses such as Lord Armstrong and the Security Service witness heard by you on the 11th of March. So well before the 1987 general election, there were rumours related to sexual misconduct on the part of Mr Morrison. As a result, it's difficult to see what was truly new in 1988, 89, 90 from the perspective of political opponents when the so-called agreement for Mr Morrison to stand down is supposed to have been made. Furthermore, the rumours were widespread through Chester and were not confined to the political community. Ms Russell's evidence on this was confirmed by Giles Brandreth MP when he campaigned as the new prospective candidate from 1991 to 1992. So that is the backdrop, Madam, to a supposed agreement in 1988 to 89 or thereabouts, and as to whether such a suggestion is a credible one. Now, you heard, of course, firstly about a discussion in a pub involving Ms Lee, and also from Mr Nichols about what he said he'd heard from Ms Russell. A discussion in the pub after a local meeting of the Gresford and Rossett Labour Party, so in the Wrexham but not the Chester constituency, in 1989 or 1990 was recalled by Ms Lee. And Mr Lucas MP also confirms that at a pub gathering, a local journalist stated that Mr Morrison had been arrested in the Crewe railway station for some sort of sexual offence. And both agree that the story was not subsequently reported in the press. Ms Lee says that she then learned that an official caution was given by the police. At the hearing, I think she said that it was probably a caution, apparently at the request of the Prime Minister's office, she said, and in return Peter Morrison would stand down at the next general election. We note that this account, of course, involves the Conservative Party and the Chief Constable of Cheshire, but not the Labour Party. But there are a number of puzzling features. There's the fact that there's no evidence of such files in such events in police files. A caution should leave a trace. In addition, police cautions can only be given, we understand, if the person in question admits the offence. Now, judging from the evidence about Mr Morrison saying that he welcomed rumours being printed so that he could sue and clear his name, this perhaps seems unlikely. Nor, we suggest, would it actually be wrong to print details of a police caution recently given to a public figure. So why did the press agree to back off if this had all happened? So this is all beginning to involve a great deal of speculation. Ms Lee, of course, also says that she spoke later to Mr Lucas, now Mr Lucas MP, about this agreement and about publicising it. And she was told, she said, that he'd already raised this with an unnamed figure higher up, and he'd been told that we just don't do that. For everyone they've got, we've got one. Now, you may think it surprising that if Jane Lee had heard such a dramatic or worrying statement, she didn't try to find out just who had told Mr Lucas such a thing or follow it further. Taking her evidence at face value, this was all, by her own account, very alarming stuff, but she didn't seek to explore it further. In addition, you have now two written statements from Mr Lucas, which have been adduced in evidence, emphatically denying that such a conversation ever took place. It is important to place that squarely on the record. He's plainly very upset by this allegation. Your inquiry has chosen not to call Mr Lucas to test his evidence, which would generally mean that you are content with its contents and will accept them. And we submit that it would be wholly wrong not to do so, given that you've not heard from him. There's then, of course, the evidence of Mr Nichols, who spoke of being told by Christine Russell of a deal between the local Tories, the local press, the police and the Labour, that if Peter Morrison stood down, the matter would go no further. Now, you heard from Mr Nichols, and the statement of Ms Green was adduced. Neither she nor Mr. Nichols can explain exactly who agreed to these two things, and there's also, again, great vagueness about dates. Now, Christine Russell does acknowledge that there were rumours of an agreement. She also notes that she would have heard of Mr. Morrison's plans to retire and reported that back to the constituency Labour Party, as might be expected. But crucially, she denies being party to any agreement or hearing that Labour was. And Giles Brandreth MP also did not support the suggestion of an agreement. He didn't hear any whispers of it at the time he went to Chester as Mr. Morrison's successor, despite extensive local contacts and conversations with local key players. Overall, there is no evidence, we understand, from witnesses from the Conservative Party or the police to support this suggestion. There's also silence or absence of any evidence from members of the press to support the suggestion of a deal. Yet those three bodies were in fact the key players in any agreement. You may also wish, we suggest, to step back and look at some inherent plausibilities, or the lack thereof, particularly with regards to the suggested involvement of the Labour Party. First, we've made the point that the rumours of sexual misconduct were not new rumours, but old ones by 88 to 1990. It's very difficult to see hard evidence of any further events since then, which would have changed the electoral landscape since that date. So what had really changed to trigger any such agreement? Secondly, and perhaps more fundamentally, how did being a part of any such agreement make any sense from the Labour Party's perspective? Mr. Nichols couldn't really give a reason when he was asked, we suggest. And you've seen the reaction of Ms. Russell. She said in her statement that it wouldn't have been in the electoral interests of the Labour Party to make a deal as, quote, the rumour mill was doing an excellent job at eroding Conservative Party support in Chester. She said further in evidence that there wouldn't have been campaigning on rumours in any event. And Madam will set out in our written submission the evidence that I'm quoting about when she said that she gave evidence that she told activists that although they could talk about Mr. Morrison's very right-wing political beliefs on the doorstep at any time, they weren't to go gossiping about the rumours. We've no evidence. It's all rumours and allegations. So if Mr. Morrison continued as a candidate, there were real and perfectly valid, we would submit, reasons why a party wouldn't campaign or actively seek to make political capital out of rumours such as these. If Mr. Morrison stayed, those barriers existed. But if he decided to step down, why would the Labour Party be required to agree that they wouldn't campaign on these issues? He would be old news, and any rumours would simply lose their relevance. In other words, the Labour Party wasn't a sensible party to any agreement. What would it add? So we do say, Madam, that fundamentally the tale of a deal with Labour doesn't make any sense. Madam, when judging events of so many years ago, when recollections we accept can honestly differ and be distorted by time, you need both to look for real and credible evidence and to apply a yardstick of common sense. And we submit that on both grounds, the idea that unidentified members of the Labour Party would be party to an agreement with regards to Peter Morrison's political future is to be firmly rejected. If I could turn then to the Whip's office, you've heard directly from Mr. Nick Brown in evidence, and our first comment on that evidence is that having heard it, we would submit that there's no basis upon which it could be said or concluded that the Labour Party Whip's office has or ever had, since 1964 at least, a black book, or that its whips collected and then used for party advantage evidence that any of its MPs were involved in the crime of child sexual abuse. Mr. Brown's evidence was quite explicit on that point. He told the inquiry also that he'd said that only objective evidence was to be gathered by whips, not subjective opinions or gossip. And he was pressed on that quite properly by the inquiry counsel and remained quite clear on the point. He added that the lips in the Labour Party were not part of the establishment, and I cannot envisage any of them being party to a cover-up of a serious allegation of child abuse. He was equally clear that if he'd heard that any stories were going to hit the press, all that the Whip's office could do would be to brace themselves. There isn't any intervention I could make to prevent publication, and nor do I think it would be a proper thing to do. Finally, Mr. Brown gave evidence that if serious and credible evidence of criminal conduct was brought to him or the Whip's office, he would either report the matter directly to the police or would advise the person reporting the matter to do so. He told the inquiry that he would report the matter himself if the evidence seemed on the face of it a subject for concern. Then I would take it upon myself to do so, he said, and he had regular meetings with the police that would enable him to do that. He also made it clear that he hadn't actually had to deal with any issues related to child sexual abuse or had to address these issues. That, of course, takes me on to the evidence of Professor Thoburn and the safeguarding policies and procedures developed by the Labour Party. Now, we heard, of course, from Professor Thoburn on the 26th of March, and she commented that the new policies submitted under cover of the witness statement of Ms Formby pulled all the previous work together in a more coherent fashion. She noted that the party had sought input from the NSPCC and had worked on training and DBS checks. They'd appointed 16 safeguarding officers. The safeguarding policy was very clear on the Labour Party website. Overall, she said the policies were now rather better than several of the others, that is, political parties in context. Some of them have a long way to go. Having heard her evidence, although the Labour Party will of course be checking the general recommendations made by Professor Thoburn against its policies to ensure full compliance, we have been encouraged by her comments. We submit that they did acknowledge the existence of appropriate policies backed by training, audit, and the appointment of safeguarding officers. Now, she was, of course, asked about the evidence of Mr. Brown that I've already referred to, and she commented that she would have expected referral of any concerns to the safeguarding manager. And this is, of course, the issue that was picked up by Slater and Gordon in the submissions before you this morning. Now, we accept that this should have taken place, or would now take place, should now take place, given the policies in place, and furthermore that such a referral would have led to rejection of attempts to triage or otherwise assess the allegations heard. But, Madam, there is often in many contexts a potential gap between policies and their practical and full implementation, and that the evidence implies that there's still work to be done to embed knowledge of the policies into the party and its members is something we accept. We are certainly not complacent. However, we would also respectfully point out that Mr. Brown was clear that he hadn't actually been faced with a situation which required him to exercise any sort of judgment with regards to allegations of sexual abuse, child sexual abuse, or to triage, still less to discard any allegations. Considering such allegations might well, of course, have been the very point at which policies were checked and advice sought. So the importance of this point, or the evidence that you heard, shouldn't, in our respectful submission, be exaggerated or in particular used to single out an individual who has not, in fact, let children down or actually failed to follow procedures in any way. We do accept that these safeguarding policies are relatively new, and so the fact that knowledge of them is not yet second nature isn't perhaps surprising. What you have in the statement of Jenny Formby is evidence not only of the development of policy, but also of the training that has and is still being undertaken, and also of the process of audit of implementation that's been developed. Even if there's work to be done, the evidence before you, we submit, suggests strongly that we are a learning organisation with a commitment to getting this right, and a strong commitment to building a safeguarding culture. Present here today beside me and throughout the relevant parts of this module has been the safeguarding manager for the Labour Party. We do take this incredibly seriously, and I have to comment, in fact, Madam, that we are the only political party that has taken the attitude of attending here, attending in person and also applying to you to be allowed to participate as a core participant. It was also because of the desire to get this absolutely right and a lack of complacency that we explicitly asked for the comments of Professor Thoburn on the Labour Party policies, and we hope that her favourable judgment on that issue will not be lost, but recognised by explicit acknowledgement of what has been, I would submit, really quite excellent work by my clients. Madam, in conclusion, we hope that these comments will be useful to the inquiry. We wish to make it clear that we have been assisted by the inquiry's scrutiny of policies and practice on child safeguarding, and we wish you well, you and the members of your panel, in your task of completing this investigatory module. Thank you very much.
Thank you, Ms Green. Now, I understand that Mr Wagner would wish to say a few words of clarification.
Just very briefly. Earlier, a woman in the viewing gallery...
Sorry, Mr Wagner, you're not...
Talk up. Thank you. Thank you, Chair, for giving me this opportunity. Earlier, a woman in the viewing gallery appeared to take offence at a particular section of my submissions. And I've not spoken to her, but I have reviewed the transcript, and I see that I missed out a word in that section, which I intended to say, and I'm grateful for the opportunity to correct the record, if I may. I said, quote, "The Elm Guest House is equally fantastical," which I didn't mean to say. What I meant to say was the Elm Guest House list is equally fantastical. And of course, the Elm Guest House existed. I do not intend in any way to underplay events which occurred there, and which, as I said in my submissions, had nothing to do with my client, Harvey Proctor. Thank you.
Thank you, Mr Wagner. Ms Beattie.
Yeah, we invite you to adduce some final documents. The first are two sets of documents about Peter Hayman. The file about Peter Hayman dated October 1980, CAB 4043. And the second is the file about Peter Hayman dated October 1980 to March 1981, and that is CAB 4071. Next, there are several documents to help give a complete picture in relation to the GB scoping report, which was referred to in the evidence of Commander Roper on day 2 of this hearing. They are MPS information held on Tom O'Carroll, which is OHY 003725. The witness statement... sorry, I'm just asked to clarify, it's pages 1 and 2 of that document. The witness statement of GB dated 20th of December 2016, OHY 005577. The witness statement of GB dated the 26th of July 2017, OHY 005584. The Metropolitan Police Operation Winter Key Interview Plan GB, OHY 005576. And documents provided by Operation Hydrant relating to GB, OHY 005586. And Chair, we invite you to produce those documents.
Yes. Mr Altman.
Chair, you will recall that just before this investigation hearing commenced, one journalist made public information that was confidential to the inquiry and to its core participants. The solicitors of the inquiry immediately took steps to investigate what had happened. All those with access to the documents in question, inquiry staff, core participants, and their legal representatives were required to complete a questionnaire. The questions concerned their access to inquiry documentation and any contacts with the journalist in question. The investigation concluded that there was no suspicious activity on inquiry IT systems in respect of these documents. The documents had been disclosed to core participants and their legal teams and were due to be used during the inquiry hearing a few days later. All core participants and their legal representatives with access to these documents had completed an undertaking by which they promised to keep information disclosed by the inquiry confidential
unless and until it was made public by the inquiry during the course of its hearings. Some had viewed the documents, some had printed them, as they were entitled to do. During the course of the inquiry, there were yet further breaches of confidence, which led to the same journalist publishing yet more information disclosed to core participants before it was heard in evidence. And this included the evidence of witnesses from MI5 and from MI6, as well as others. Each further incident was also investigated. There was no public interest in the journalist making this information public, simply gaining advantage in publishing the information as a scoop. The information was due to be made public by the inquiry just a few days following publication. We've not asked the journalist who it was provided him with this information while it was confidential. As a journalist, he is entitled to protect his sources and doubtless would not reveal his source if asked. It has not been possible to identify the source of the leak or leaks of this confidential information to the journalist. Extensive examination of the inquiry's systems has produced no evidence to suggest that this information was leaked by anyone at the inquiry. Although we can't exclude the possibility that someone at the inquiry provided this information to him, it's very unlikely. Doing so would breach their terms of engagement with the inquiry and would result in the revocation of security clearance, which is a prerequisite for their employment. We conclude, therefore, that this information was provided to the journalist by a core participant or their legal representative. Legal professionals who break an undertaking given to the inquiry risk disciplinary proceedings by their regulator and being struck off or disbarred as the case may be. This reflects the seriousness of breaching a promise of this nature. Core participants face fewer sanctions, although breach of the inquiry's undertaking in the context of this inquiry may amount to a criminal offence under Section 1, Subsection 1 of the Sexual Offences Amendment Act of 1992, where a person whose identity is protected by lifetime anonymity is published. Although it appears that no further steps can be taken in relation to these particular incidents, I know that you, Chair, rightly take the matter very seriously. In your determination of the 27th of July 2017, in the Roman Catholic Church investigation, you explained the importance of the inquiry being able to provide disclosure to core participants in circumstances of confidentiality. Breach of that confidentiality has the potential in future to affect all core participants, whether complainant core participants or institutions. Now that the hearings in the Westminster investigation have been completed, you have asked the solicitor to the inquiry to terminate the access of core participants in this investigation to the body of disclosed documents, and that will be done today. Going forward, core participants will be entitled to request access to documents on the provision of reasons, for example, in order to prepare for making further submissions in writing by April the 12th, or in order to respond to Rule 13 warnings. Core participants will, like everyone else, continue to have access to the documents and material adduced in evidence posted on the inquiry website. You have also asked that we give very serious thought to the quantity of disclosure documentation given and the means by which it is provided for future investigations. Finally, the solicitor to the inquiry is also putting in place technical measures to make sure that any information disclosed in breach of the undertaking in future is traceable to its source. So that's all I have to say at this juncture. Thank you, Chair.
Thank you, Mr. Altman. As you've pointed out, it is indeed a very serious matter when anyone breaches their promise to the inquiry to hold information given to them in confidence. It obstructs the inquiry's ability to do its work to make recommendations to protect children from sexual abuse in future. And anyone considering breaching the inquiry's confidentiality undertaking in future should be in no doubt that their access to inquiry systems, any funding for representation, and all documentation will be withdrawn immediately if they are identified as having broken their promise. Any such breach by a core participant personally is also likely to lead to my withdrawing their core participant status, so they will have no further role in the inquiry. Thank you all for the closing submissions you have made today, and of course that concludes the public hearings in the Westminster investigation. We are grateful to all of the witnesses who have come to testify before the inquiry during the hearings, and in particular, of course, to those who have told us about possible failures of many different kinds in the institutional responses to child sexual abuse, and the witnesses from political parties and political bodies, and to all others from whom we have heard our thanks. We are also very grateful to all of those who have gathered and sent evidence into the inquiry for the purposes of this investigation, even in these last few weeks. Your efforts in bringing information to the inquiry's attention are very much appreciated, and it will all be considered. Finally, we'd like to extend our thanks to all of the representatives here for their assistance, and to all of the inquiry staff for ensuring the smooth progress of the hearings. We will now review all of the material provided to us and prepare our investigation report, which we are aiming to publish early next year. With that, I will draw these hearings to a close. Thank you very much to everyone.
Madam Chair, before you close, may I very briefly say something in response to Mr. Altman's submission on the leak issue? I will only take a minute.
Go ahead.
Madam Chair, we're grateful for the update by Mr. Altman about the leak investigation. However, we remain deeply concerned about a particular separate issue which we raised with the inquiry almost a month ago. As you know, Chair, we wrote to the inquiry on the 4th of March 2019, raising our concern that some of the contents of an email, which was sent by a member of Harvey Proctor's legal team to the inquiry's legal team, and only to the inquiry's legal team, appeared to have been leaked to a journalist, the same journalist we think that Mr. Altman was referring to, who tweeted about them a few days later. As you know, those tweets appeared to quote directly from the email and revealed a piece of information about Mr. Proctor's legal team, which was not known outside the inquiry and Mr. Proctor's legal teams at the time. We wrote to you about this on the 4th of March and raised the very worrying possibility that the leak came directly from the inquiry team, as who else could it have been? We have subsequently duly filled in forms confirming nobody in our legal team leaked the information, and why would we? And we've heard nothing more. And with great respect to Mr. Altman QC, his statement does not assuage our concerns, and we submit that in order to put pay to Mr. Proctor's concern and also safeguard the ability of participants to continue to trust this inquiry and its team, a full report on the leak should be published publicly as soon as possible. Thank you.
Thank you, Mr. Wagner.
Chair, we note Mr. Wagner's comments. They were mentioned to us over the lunch break, and they are part of the ongoing review. Thank you.
Thank you very much. We'll now rise.